May it please Lordship. Lordship, item number 29. As per PP instruction, the case diary is not available.
29.
29.
Case diary not received. Petitioner is in interim money.
You are on interim. You are on interim.
Yes, Lordship.
Yes.
My lord,
Interim be extended. Reminder, yes.
on 3rd of September.
3rd of September.
Mm.
3/9.
3/9.
Your interim will be extended till next year. Yes.
Most obliged, Lord.
May I please, Lordship? Back to item number 35, my lord. Lordship, matter may pass over for the my lord.
35. It
Yes,
is
my
a
lord.
case of 2012.
Yes, my lord.
Why you need an adjournment?
Lordship, my senior is not even in the court, my lord.
Your senior is?
Out of station.
Who is your senior?
Ajay Bolbuya.
After 2 weeks, it will be listed. After 2 weeks. After 2 weeks.
Yes, my lord.
May I please, Lordship? Lordship, pair for listing a bail application, Lordship. Lordship, 302 and 120B is there, Lordship. Lordship, this matter supposed to be, as per last order, this matter supposed to be come up on last 24 July, Lordship. But it is not yet listed, Lordship.
Tomorrow may not be possible, day after tomorrow.
Lordship. May I please, Lordship? Lordship, with the consent, I beg to mention item number 40 on my lord. My lord, my senior is now out of station, my lord.
40.
40
1
on,
crore or 40?
4 on my lord.
41.
Yes, my lord.
41.
41. Yes, 41.
Achha. Why you need adjournment?
My lord.
Why you need adjournment?
Yes, my lord. My lord, my senior is now out of station.
Who is your senior?
Zaid Hussain, legal counsel, my lord.
Jed Hussain. You are for the respondent.
Yes, my lord.
Have you taken consent of the other side?
Yes, my lord.
Consent of the other side on behalf of Jed Hussain. Legal counsel. It's okay. Okay, it is adjourned. It will be listed after 2 weeks.
May I please, Lordship? Lordship, I beg to mention items 37, Lordship. For adjournment, Lordship.
37.
37, Lordship. This is all pending matter, Lordship.
Yes.
In this matter, earlier, learned senior counsel Mr. S.N. Sharma was conducting this matter, and Mr. A. Jahed was assisting him. However, unfortunately, learned senior counsel passed away, and then Mr. A. Jahed is also no more associated with us. Therefore, we'll need some instruction from the client whether they want to engage senior counsel or not. So, Lordship, may kindly accommodate us 2 weeks' time, Lordship.
You are on 37.
37, Lordship.
37 till now the respondent is not appearing. Do you have any
It is not shown in the post list, otherwise.
names are not shown? That's why I'm asking.
Yes.
You are Mr.
El Sangam, Lordship.
Mr. L. Saka, the learning counsel for the petition. It is submitted that the conducting counsel, Mr. S.N. Sharma, it's expired, and at present Mr. A. Jahid is conducting the case. However, he needs some more time to take instructions from his client as to whether the petitioner gets any other for the prayer according to you are giving only 2 weeks time because it's a old pending matter.
Much obliged.
May I please, Lordship? I beg to mention item number 18. So I am for the respondent. The petitioner is here. LCR was called for in this matter. LCR has not been received.
18. You are for the petitioner or?
I am for the respondent.
I am for the petitioner.
It was called for, no?
It was called for. It has not been received.
Tuesday, na?
So yeah, the forest is also in Assam forest. Or the state of Assam only. State of Assam is.
State of Assam is also there.
Forest department is not here.
No, forest department is not here. Item 18.
Yes. LCR to receive Quran, yeah. Article and cost subjected LCR because called for. It's not yet received, and that date will be required for the certificate for the hearing of the case. You should remind the distribute for at least accordingly. After 2 weeks, will do
My lord, on 20th of August, my lord, 20.
2-0.
My lord, 20th of
You
August,
want a fixed date?
my lord, yeah.
Good. We're fixing it with 2-0 and we're issuing reminder.
Much
That's
Obliged.
M Fukon
Much obliged.
May I please the lordship. Lordship, I beg to mention item number 25, madam. Kindly, this matter may be taken up next week, madam. Anticipated bail application interim is not there, madam.
25.
Yes,
25 case diary receipt, man.
You took adjournment. Case diary is here.
Yes, madam. There's no
What?
interim, madam. Next week, madam. Any date.
That's what we are saying. You are not interim. If we have received the case diary,
Madam, I have to leave the court, madam, due to some medical.
the request with Thailand counsel for the petition. Matter is adjourned. However, it is submitted by Mr. Keyboard that the case diary has already been received. Next week, any date?
8th of August.
8 of August.
8.
Obliged, madam.
August. Written date is that.
May I please? 439, man.
Yes.
392. So CD may be called for.
Now not 439.
Man. Sorry, man. 483. Man.
Yes. Now 483. Yes. So CD has to be called for.
Yes,
Mala
man.
Sipa Jhar, man.
Date of various on 10/7/24, man.
Yes.
When?
On my lord, it was here. 30 on 14th of August.
Mala, let it be. No, 14 na lage. I just after 15.
Deri ke.
Man, 15 or
16, 16 8 then.
16A,
16.
All that, man. 14. Let it. 14.
14. Okay.
Hello.
May I please your lordship?
Yes.
For 483 bail application. Lordship, accused number 1 is for behind the bar for 14 days and accused number 2 is for 12 days. Lordship. CD may be called for, lordship.
Voter list 329, 64, 76, 351, 35. You have to go to case report now. Basically, this is a case of 30 Gurunadanuna for hiding child.
Yes.
Okay. So, yes,
My lord, on 16
16.8.
16.
It will
Highly obliged. May I please your lordship?
yes, ma'am.
483 application, lordship. Lordship, allegations are under section 109 and 35 of BNS.
109 is any murder, sutter, or what?
Yes, basically 307 of IP.
307. And
Chip, ma'am.
35 is
Forwarding report is at this.
boarding report is it? Page
12.
So they are in custody since 20.
Yes, 27. CD will be required.
When can be called?
CD on my lord. 9/8. my lord.
9/8.
Oh, 9.
9/8.
No, lordship, short date may be given because
on my lord,
although his
14/8. my lord, 14/8.
although his name is there in the FIR,
but the present accused person has no involvement. He is a government servant. Short date may be given, my lord, for CD with the injury report.
Then, my lord, 12 wait, my lord.
CD along with the injury report. Lord. Obliged, sir.
May I prevail? As on 14/4/24, Lordship. And DPS case, Lordship will call for a diary and this thing. 108
commercial.
days in custody.
Commercial.
Not commercial, 22 bottles of this cough syrup. So from the portion of the accused, from the other accused, commercial quantity is there, heroin is there.
Anyway, case is registered under commercial.
Commercial.
Yes, important.
On my lord,
Gauripur, it's from Gauripur.
19.8, my lord.
19.
19.8.
Much.
Why? Oh, here one case is there. One request was there for VC, and we fixed at 2.
My lord, who is appearing? I'm sorry, my lord. This is motion matter, my lord. Somebody appearing, my lord.
That I don't know, but it was a request from one Manish Kumar Agarwal.
To respondent number 2.
He is going to appear in person.
Otherwise, notice are not issued.
That is the difficulty. Request is already most probably granted. I thought once that they did not be, but it was already granted. He is in Kolkata or somewhere. That's why the request was there. So otherwise, he is for the respondent.
He is the respondent number 2, my lord.
Respondent.
Notice is not been issued, so whether he is even to be heard or not, that is also another issue. Motion matter, my lord. Anyway, I leave it to your lordship, my lord. If lordship has already granted the request, then my lord.
Yes. It will be at 2.
Deeply agree.
Time before show.
May I please your lordship? Your lordship, this is a 482 anticipatory bail application. The FIR is at page number 11. Your lordship, one unique fact is that there is no FIR named accused, and absolutely it is against some unknown person. And the details are in page number 11, your lordship. It is with regards to the theft of an ATM having around 1,77,000 rupees in it, which is a Tata product indication ATM given by the informant, your lordship. Now, based on this particular FIR, where there is absolutely no persons indicated to be this on suspicious ground, the police has mechanically arrested 2 persons. I am the petitioner. I am not connected with the persons who are arrested for accused number 1, but accused number 2 is my younger brother. However, your lordship, both the petitioners in this instant matter, if your lordship may kindly see annexure number 4 at page number 23, the cause of the occurrence and this theft happened in Hojai district, and I am a resident of Sibsagar district, your lordship. I am just the elder brother of the accused person, and the police has written in the forwarding that this accused person has said that his brothers are involved. Which brother, what brother, nothing has been mentioned, your lordship. Your lordship, furthermore, with regards to the petitioner number 2, there is absolutely not even one single name material against the petitioner number 2. With regards to petitioner number 1, only and only one sentence is used that my brothers are involved. If the police is searching for me in a place where I do not reside, how can the police find me, your lordship? Therefore, I am willing to participate in the investigation. I am also ready to go for the CDR if the police wants the CDR on my phone and everything. I am willing to submit everything to prove my innocence, your lordship, if I am granted interim protection.
Serious offense, my lord. CD, my lord, I will get the case diary on
Your lordship, I will
28, my lord.
Let us see the progress first. If necessary, on the receipt of the case diary also interim can be granted. Let us see.
Yes.
So now we are not at the stage to grant you interim at present.
Yes.
So we are calling for the case diary. Let
Yeah.
it be a short date.
Your lordship,
We peruse what is the ingredients, how, from, why, on the what basis you are searching by the police, and is there any involvement of your?
your lordship, it will be much clearer if I can go and participate in the investigation, your lordship.
See the call. When can it be called?
My lord, on
Long date. Yes.
16-8.
16-8.
16-8.
Much obliged. Much obliged.
May I please, Your Lordship. Lordship, in this case, on last occasion, Lordship, it was observed that the case has been filed under the provisions of the CRPC. So it ought to have been under section 482. So accordingly, on 26/7/2024 itself, we have filed a IA. But I've gone through the record, Lordship, the IA has not been tagged. So Lordship may kindly direct the registry to take the IA, and the matter may kindly be taken up at 2, my Lord. There is an urgency, my Lord. He is a government servant. An absolutely false case, my Lord.
At 2. আমি আনি দিওঁ নহ'লে সোনকালে অৰুণাচল And at 2, there are 3-4 matters are already through. 2 through BC, 3 from through BC, and other matters are there. So at 2, I don't know. Let us see if it comes within this week. We are just going to.
Lordship. Lordship.
Otherwise,
Obliged.
my lord, from the contents of the FIR, the injured himself, my lord, stated that the present accused person is involved in committing the offence, my lord.
Lordship, I was
So
admitted in
accused was
hospital, Lordship.
initially treated at, my lord, PSC Tamulpur, and thereafter shifted to, my lord, GMC for better treatment. And in GMC, my lord, later on the injured himself stated the present petitioner's name. my lord.
Lordship, I was the
So,
person who
on
was
the
admitted in the
schedule, we will-
hospital. I will come to this, Lordship. Let the IA be taken with the case record.
Yes.
Obliged, Lordship.
I is not showing.
Lordship,
Have you filed the I when?
on 26/7/2024 itself, I have filed the IA.
We confirm the from the section.
Lordship,
Now it's not showing in.
Lordship. Obliged.
Item 8 is 302.
Yes, 302 is there.
None appears. None appears on call for the application. List of property.
May I please, Your Lordship. 482 application praying for anticipatory bill, my lord. FIR at page number 8, my lord. The allegation is that the accused person running a drug rehabilitation center and the informant is a drug addicted person. He admitted in the rehab center, my lord. Thereafter, the accused person used to torture him. This is the allegation. And FIR has been registered for 341, 325, 326, 334 ABC, except 326 all are available. And the main accused, my lord, case number 1, he was arrested, and the Lanet court below granted bail to the accused number 1 on the ground that the 326 is not applicable as the injury is simple in nature and caused by blunt effect.
Your petitioner, you are accused number?
2 and 3,
You are the accused number 2 and 3.
lordship. The Lanet court
So
below held that the
against two, there is specific allegation in the FIR itself.
lordship.
And my
Against
lord, in the name of running, my lord, all these rehabilitation centers, my lord, in these rehabilitation, they actually, my lord, tortured those, my lord, victimized persons. My lord, there are many instances of this, my lord, this type of incident going on in those rehabilitation centers. Because in the name of running rehabilitation centers, they, my lord, earning money from the state, and thereafter, my lord, physically, mentally assaulted all these persons, my lord, in the name of, my lord, curing them.
He is a drug addict person, my lord.
Maybe a drug
He is a
addict person, but
FIR has
in many
been
cases it happens that
registered under
instead of
my lord,
providing treatment,
yes.
my lord, they in fact, my lord, harass those, my lord, physically, mentally, my lord, tortured those, my lord, addicted persons.
except 326 all are available. And Lanet court below held that 320, there is no material of 326, my lord. After perusal of case diary, my lord. Kindly peruse the order, my lord.
have we approached this the court below earlier?
Yes, lordship appraised, but I could not annex the order, my lord. That was rejected.
Yeah, one observation is there from the learned trial court below that the injury was simple and blunt. It was as per medical report.
Yes.
Heart blister. HAM and counsel for the petition also heart blister report. Plan acquisition PP brain on the upper stage of and synaptic section switch connection with switch. Next, right, is submitted by Mr. R. That represented and no such incident had happened as anything FIR. The informant was a drug who was admitted to the center of the patient and petitioner. He was providing treatment in their rehab center, but he lost the FIR with some cause and concocted Murder submitted that the Learned Trial Court had already granted bail to case number 1 after perusal of the case diary and considering the medical report, which shows that the accused, the victim sustained minor injury caused by blunt obstruction. However, it is ready to support the commission delivery. The case diary will be required. This is to call for the case diary along it. Okay, will be under interim protection.
All right.
Appear before the IO within 7 days and cooperate them. Yes, what?
On 11/9, my lord.
11.
Hello, please.
Yes.
My lord, 482 application. In this case, my lord, the petitioner is a student of 5th semester BA, my lord, and he is of 20 years of age, my lord. Kindly see the FIR, my lord, at page 15 is the relevant portion, my lord. Type copy.
Yes.
May I read, my lord? With due respect, I would like to inform you that I am Gita Sorgiari, age 20 years, daughter of so-and-so, village so-and-so. I am to state that from 23/5/23 to September 2023, I was in a rented house in Sishpura Talukdar village so-and-so. As I was reading in class 12 of Pioneer Academy, Borama. During that period, I was in love relation with Manjit Talukdar, that is the petitioner, my lord. Who is the son of Chakra Talukdar. At that time, he knows my Instagram ID and password. He frequently went to my room and made forceful sexual relationship with me and threatened me not to tell anyone. Otherwise, he will kill me. He also took my naked photos after I had break up with him. He uploaded my naked photos on my Instagram account so-and-so, as well as sent to my friend via WhatsApp by creating fake account. My lord, the allegation, as per this FIR, my lord, the incident took place more than 1 year ago. But for 1 year, she was more than 1 year, she was silent, and she has disclosed that she has not disclosed that fact to anybody, my lord. Not to moreover, she has concealed one fact that in that rented room, she was with her elder sister, who was also a student, my lord. That was concealed by her, my lord. How is it possible, my lord, in a room where she stayed with her elder sister and in the same compound, how could it be possible, my lord? And if it is done or it is the offense is committed by the petitioner, why she was silent for 1 year or and did not disclose it to anybody, my lord? Moreover, my lord, there are several cases, my lord, of the Honorable Court where it is on 2 grounds mainly, not disclosing to anybody or delay in lodging the affair, my lord.
Okay. Yes.
No, very serious allegation.
No, my lord, after 1 year.
Your lordship, after 1 year, my lord, for this time of the, my lord, occurrence is not a vital because, my lord, later on these photographs were made viral, and it is not only allegation that that he threatened to make viral those photographs, but in fact, my lord, already those photographs were, my lord, already uploaded in various, my lord, social media in the name of in a fake account.
So, and learned trial court after perusing case diary also rejected the bail. So, at this stage, my prayer before Lordship. CD
My
may
lord,
be-
he is a student, my lord. CD may be called for, my lord. He
Yes,
may be
of course, my
protected.
lord.
My lord, if anything goes against him in the CD, my lord, then my lord,
It is goes against you only from the order of the learned trial court below.
Yes.
my lord, he is a student, my lord.
So your one safety was rejected after presentation of the case diary by the session judge Baksa. Let us call for the case diary.
Yes.
Give you a short date.
My lord, kindly, my lord, for short date only, he may be protected, my lord. He is a student, my lord.
Yes, he is the student. He should
My
do
lord.
all this. That is
Yeah.
My lord, kindly see the, my lord, see the apex court, sorry, the honorable court decisions are there, my lord. May I submit, my lord?
no decision is there. I know. We call for the case diary.
Several cases are there, my lord. Only two factors, my lord, on which the accused or acquitted, my lord, that not disclosing to anybody, and secondly, delay in lodging the affair. Here, there is more than 1 year in lodging the affair, and she didn't disclose the incident to anybody during this period, my lord. If such a thing had happened, my lord, why she was silent, my lord?
On,
And moreover, she was in the room with her, along with her elder sister,
That is your
in the single room, my lord.
on 14/8, my lord.
Till then, my lord, he may be protected, my lord.
okay, you'll be protected. 48.
14/8.
Submission of the file. Yes, also come. And one letter. Okay, 49.
Obliged, my lord.
Your Lordship, kindly, item number 8, I have presented too late for my illness. Item number 8, my lord,
About your illness.
already crossed over.
So it was listed for after 1 week. You had
My lord, kindly, she is woman, a mother of 4 children,
case matter.
and her husband is also in jail in the same case, my lord.
No,
Kindly
what
put,
about 302 matter?
kindly, woman, you know, specific, there is no specific allegation against her. Kindly,
No,
interim protection.
already order has been passed.
Yes.
Kindly interim protection, my lord.
No, 302. I think.
Yes, well, CD may be called for.
He is woman actually.
After 1 week, city call for. One can be fixed.
On my lord, 19/8.
98. Obliged, my lord.
We are calling for the case guide.
Yeah, please, Lordship. Lordship, this is 42 bail application, Lordship. Lordship, FIR, Lordship, FIR is it case, Lordship, 13, Lordship. Vernacular part is, Lordship, case 16. Lordship. Case 16, Lordship. Lordship, may I read, Lordship? Lordship, this is by one Meena Begum. Lordship. মহাশয়, সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা প্ৰায় 8 বছৰ পূৰ্বে মোৰ ছোৱালী বিজুমণি বেগমৰ লগত 1 নং পদকীয়াৰ সৈতে ধৰ্মীয় ৰীতি নীতিৰে বিয়া হয়। বিয়াৰ পিছত কিছুদিন থকাৰ পিছত প্ৰথমে এজনী কন্যা সন্তান জন্ম হয় আৰু পিছত এজনী কন্যা সন্তান জন্ম হোৱাৰ পাছৰে পৰা 1 নং পদকীয়া ছোৱালীজনীৰ স্বামী 2 নং দেউৰ 3 নং দেউৰ 4 নং ভাই শহুৰ আৰু 5 নং পদকীয়ানী জনী সহ লগ লাগি মোৰ ছোৱালীজনীক যৌতুকৰ উন্নত মানদণ্ডৰ সা সামগ্ৰীৰ লগতে নগদ ধন বিচাৰি দিনে নিশাই নানান শাৰীৰিক মানসিক অত্যাচাৰ চলাই আহিছে। যদিও মোৰ ছোৱালীজনীয়ে সংসাৰৰ খাতিৰত সকলো অত্যাচাৰ আমাৰ পৰিয়ালক নজনোৱাকৈ নীৰৱে সহ্য কৰি আছিল। ইতিমধ্যে 1 নং পদকীয়াই আমাৰ পৰা 1,40,000 টকা নিছিল। এনে অৱস্থাত যোৱা 16/7/2024 তাৰিখে ৰাতিপুৱা প্ৰায় 11 মান বজাত উপৰোক্ত পৰিয়ালগণৰ অত্যাচাৰৰ সীমা অতিক্ৰম কৰাত অসহ্য হৈ মোৰ ছোৱালীজনীয়ে বিষপান কৰে। পিছত সংকটজনক অৱস্থাত পদকীয়াগণে মিছাকৈ গুৱাহাটী মেডিকেল কলেজত হস্পিটেলত ভৰ্তি কৰায়। যদিও মোৰ ছোৱালীজনীয়ে তাতে শেষ নিশ্বাস ত্যাগ কৰে। উক্ত সমস্ত ঘটনা আমাৰ পৰিয়ালক পদকীয়াগণৰ পৰিয়ালে জনোৱা নাছিল। পিছত গম পাওঁ আচলতে উক্ত সমস্ত ঘটনাৰ ব্লু প্ৰিণ্ট ৰচনা কৰি পদকীয়াখনে মোৰ ছোৱালীজনীক বিষপান কৰিবলৈ বাধ্য কৰোৱাইছিল। পিছত ছোৱালীজনীৰ মৰণোত্তৰ পৰীক্ষা কৰি পৰিয়ালজনৰ গাঁৱতে সৎকাৰ কৰা হয়। Lordship, these are all Lordship presumption, Lordship. There is no Lordship any suicide, no Lordship any injury. They have participated in the ritual, Lordship. Thereafter, they have filed. On 16, it was 7, Lordship, and it was FIR was filed on 19, Lordship. And this is admittedly, Lordship, this is the marriage was solemnized prior to 8 years, Lordship. Lordship, this part as per the section on 17 of the Bharatiya Sakshya Adhiniyam, Lordship. This presumption could be drawn only if the death is happened within 7 years period. It is admittedly prior to 8 years, Lordship. And there is no.
If suppose 304B is not will not come, then 302 will come.
Lordship,
Or 30 whatever 306.
Lordship, this is registered under Lordship 108 stroke 3.30 bracket 5 BNS, Lordship. Abatement
108 NS 306. 108 BNS is 30.
Lordship, 306, Lordship. These are
It's not
all
the case of 304P then.
Yes.
A presumption, if that
At this
presumption
stage,
will come, it's okay. It will
Yes.
come in with other sections.
all are family members,
Well,
Lordship.
there is specific
Yeah.
allegation in the FIR against the
Specific
present.
allegation against you.
Lordship,
Suppose if it's 304P, the presumption does not come, then obviously will come with affect the other sections, not
Lordship.
against all.
Lordship, there is no Lordship specific statement that the deceased has informed the informant earlier that she has been tortured, Lordship. No, she said that যদিও মোৰ ছোৱালীজনী সংসাৰৰ খাতিৰত সকলো অত্যাচাৰ আমাৰ পৰিয়ালক নজনাকৈ নীৰৱে সহ্য কৰি আছিল। Now it is said. So how we can estimate what
City call,
brother-in-law, Lordship?
brother-in-law, have to do.
On
This one,
21/8.
21. We are calling for the case diary only 21.
Lordship, they may be kindly protected, Lordship. Is the Lordship is the railway employee, Lordship, for the petitioner, Lordship?
We can give you a short date then, in fact,
Yes.
where from it has to come.
My lord, from Kamalpur, my lord.
Common. Then we give a short.
Yes, yes. My lord.
I will also.
12/8, man.
We are giving it 12.
Lordship may protect us. Our statement may be recorded, Lordship. Till then, Lordship.
What CD, what is collected by the case diary. Case
Lordship,
diary.
they are employee, Lordship. They cannot go to the
Employee
employment, Lordship.
should not do all these things. Nah. He is an
They,
employee.
they are
This one is
separate.
better,
They are
but
separate
have the-
family holder, Lordship. They are not from the same Lordship household.
But mental pressure, mental torture, it can be there. No?
No, there is no Lordship.
you are
Statement
saying-
statement is
that is
not
the-
there. In the FIR does not say so, Lordship.
Obviously, that is the allegation. I won't say that you are good. 12 faithful.
12 years, Lordship. Is the sister-in-law, Lordship. Is a school teacher, Lordship.
Oh, same,
Same PS.
Same, Lordship. And
Okay.
also, Lordship.
On 12/8.
same 12.
Lordship, she may be only
Sister-in-law,
Lordship.
sister-in-law are more dangerous now.
Lordship.
What to do?
May it please, Your Lordship, the matter may kindly be adjourned for a time being, Your Lordship.
Okay.
Ms. K. Chaudhary is leading me in this case, Your Lordship, for the time being.
Okay.
I'm deeply obliged, Your Lordship.
Particular also same, Lordship. Same, FIR, Lordship.
Same FIR.
Lordship.
That means 11, 12, and 14 are of same.
Lordship, same.
This is for whom?
Lordship, husband and brother-in-law, Lordship.
Husband and oh, this is for husband.
Yeah, Lordship.
12 8. All are will be fixed at 12.
Lordship, date, Lordship.
12 8.
12 8.
12 of this August.
Short date, Lordship.
Therefore, we have
Other
no
cases
short.
on 12/8, man.
CDB won't come again. Your purpose will not serve. It will be again. We'll have to give a long date. So that's why 12 8 is better.
Yeah, employees, Lordship.
Yes, employee. I can understand.
Government
It will
employees,
work.
Lordship. Deeply obliged.
It does. 20, what is the position, Tahiri?
20, my lord.
CD we have received. Why he will have a time being corresponding in our. Let it be on time being first.
Yes.
The one is here in fact.
Yes.
One, 21. 2109.
21 also case they received.
Is there received?
Yes,
21 also.
21.
2109. I can pick up our Matibara.
21.
May I please, Your Lordship?
Yes.
Mr. A.K. Singh is having some difficulty, Your Lordship. Kindly,
In 20, item number 21,
yes, Lordship. Kindly can the matter be taken up at 2?
2 cannot be. Because 4 matters we see are there and a lot other matters are also there. Most probably 2 will not be possible.
Or
Next
else-
week, let it be on next week then. Let it be on next week then. We have received the CD will be retained. On Monday or Tuesday, we can take. 2 may not be possible at 2 because there are 4, 5 matters already been. It is. Good. 7 months.
Yes.
We can retain the case diary till
Ye-
7/7.
yes.
7/8. Sorry. At the request my report, CDDC. Let the CDPDT. So we are retaining it till 7/8 next week. (22 plus 47).
22 also my lord, none appeared.
Two night. Yes. Right. 41 plus 10. I mean, put it.
May it please, Your Lordship. Well, this is an application under now, I think 482, na? So, it will take some time to
Yes, yes. Okay.
get familiarized with the new section. Now, my lord, the FIR is at page 21. With due respect, I have the honor to state, has your lordship got it? Yes. That I am the informant of the instant FIR, acting as principal in charge of West Gwalpara College, and on the other hand, the accused person is an associate professor of the said college. As per the report submitted by the inquiry committee constituted by letter dated 2012-23, accused person has been placed under suspension issued by Director, Higher Education Assam, and accordingly principal in charge of West Gwalpara College has been requested to file an FIR against the accused person for financial misappropriation due to anomalies in RUSA scheme. RUSA is, my lord, Rashtriya Utsatar Hikka Abhijan. The accused person was allowed to act as principal in charge to look after the academic activities as per order of the Director of Higher Education, white order dated so and so, without having any financial power of DDO during his tenure. Well, look, I'll have this paragraph have relevance. I'll come to it little later. Now, an impression is sought to be given that I was made in charge principal for academic activities, and as far as financial power, it was not given to the petitioner. Therefore, how the petitioner was dealing the financial matter. But the accused person has operated so many bank accounts in the name of principal in charge of the college without financial power. As per records, he operated 3 number of bank account of RUSA Fund, Scheme a Science Fund, ASOS Fund, and Idol Fund. That the accused person removed various fund money and deposited huge amount of money fraudulently in his own account along with in the bank account of some employees and LDN Education Bureau. The total amount is calculated at 39 lakh, which is directly deposited in the account number of SBI Gwalpara, etc., etc. That the accused person has drawn and misappropriated huge amount of money in the name of traveling allowance, which shall be huge amount of 5 lakh and odd, and surprisingly has drawn 1,50,000 in the month of March 20 fraudulently, which is reflected in government audit. That the college has no generator for use in existence, but the accused person has corrupted and misappropriated the college fund amounting to 6 lakhs and odd in the name of fuel, etc., etc. That the accused person has corrupted and misappropriated 9,52,000 and odd in the name of installation of computer software in the college without installing the computer. That it is noteworthy that as per the order of the Honorable Chief Minister, White Order so-and-so Director Higher Education, White dated issued a letter to then Principal of the college to submit a detailed report of misappropriation of public money done by the Principal Abdul Wahab Mia, and thereafter the government audit was initiated. That this affair has been approved, has the approval of the government of Assam direct action. So now, my lord, the main allegation in the affair is the petitioner, though he was principal in charge, but he was only for academic matter activities, but power of DDO was not given. How come he had handled the money under RUSA? That is the allegation, my lord. Now, my lord will kindly come to page number 26. How they have resorted to falsehood, my lord, that I will establish. Handbook of RUSA, point 2, 12. SHEC, it would have state higher education. Na? An institution participating in the program shall maintain separate single account in the name of RUSA to be operated by authorized representative of SHEC or institution as the case may be. The account details will be shared with MHRD and any subsequent change in account must be done in consultation with the ministry. Now, the guidelines of the Rashtriya Ausat or Shiksha Abhijan itself says that separate single account will be open and it will be operated by authorized representatives of the college. Then, my lord will kindly come to page number 28. Now, this is the resolution of the governing body. The following, this is a type copy, original is next page, my lord. The following resolution was passed in the meeting. The meeting unanimously resolved to open a new account in the name of RUSA Fund West Gwalpara College to maintain all financial transaction of RUSA grant at the State Bank of India Gwalpara branch. The meeting authorized Principal in charge Abdul Wahab Mia and Professor Soritul Islam, Coordinator RUSA Fund West Gwalpara College to operate the account jointly. My lord, in the FIR, this GB resolution is not there. Now the impression is given is, I am a principal in charge academic. I do not have the power of DDO. How come I am handling fund? This is how I am handling fund. And my lord, all this money were not paid by me. I in fact withhold many such payments. Then my lord, subsequently, my lord, petitioner was placed under suspension on this same very allegation. Now, my lord, subsequently, my lord, the petitioner met with an accident. And in that accident, my lord, more or less his right side is now paralyzed. That is the state of affairs. My lord, in the departmental proceeding, I will deal with it, my lord. In the criminal case also, my lord, I will cooperate with the police. But my lord, the allegation in the affair is false.
He is already
Prima facie false, my lord.
he has already been placed.
I was only for a particular period, not that I was there all throughout. Now, the allegation in the affair, in my humble service, is a prima facie wrong. That governing body of college, in terms of the RUSA guidelines, given the power to me and another professor, That fact has been withheld, my lord, in the FIR. Therefore, I'm praying, my lord, let my
But the FIR
yes,
is that part may be withdrawn,
yes,
withheld. But the question is that you not only the allegation as per allegation, not
yes,
only
yes.
withhold the so and so, but in your account as per
No,
allegation.
my lord, they're all false, my lord. These are, my lord, let my learned friend have the instruction, my lord. Let me place the case there, my lord. Only because of this, my lord, I'm praying for interim protection, my lord, and I'll cooperate with the police, my lord. I'm a professor, my lord, where I'll go? I'm a person having roots in the society. Kindly see my medical condition, my lord, at page number 36. In fact, my lord, that I met with an accident, there's a police report at page 35. This is to certify that on 8/5/24 at about 4:10 a.m., an accident occurred of a vehicle that is Maruti Alto bearing registration number at so and so. In the accident, one Abdul Wahab Mia, Associate Professor, West Garo Hill, bearing their driving license number, traveling in the car as driver on his way home while discharging his election duty in parliamentary election, sustained grievous injury, hence the case. In fact, my lord, after performing the election duty when I was going back home, I met with the accident. Now my medical condition, my lord. This is to certify that Abdul Wahab Mia, bearing so and so, so and so, so and so, was treated as an indoor patient OPD from so and so till date. He is suffering from traumatic cervical cord contusion and right hemiparesis. She has undergone conservative management under, he has been a treatment of so and so, so and so, so and so. Well, virtually, my lord, I have lost sensation in my right side and I'm still under treatment. And of my own, I cannot do anything. Somebody has to be with me any time, my lord. I made those statements in the petition. So, considering this, my lord, regarding the other allegations, let my learned friend obtain the CD, my lord. Considering my status, my lord, you should kindly consider granting interim protection till the CD is produced.
My lord, from the contents of the FIR and after going through the resolution, I have also gone through the resolution, and your lordship has rightly pointed out that such a huge amount of rupees 39,20,400, those are all public money deposited in his account. So prima facie, the present petitioner is involved in my lord misappropriating the public money, which my lord prima facie reflects from the contents of the FIR. So my lord, it cannot be said that my lord allegations are false. And now, my lord, regarding Atam Dayas, he is an associate professor of the, my lord, that college, and at that point of time, he is not having the power of DDO, my lord, specifically mentioned in the, my lord, FIR. And thereafter, my lord, what happened, my lord, in this, my lord, there are also, my lord, your lordship may kindly come, one audit report. It is not that baselessly only on the basis of allegation FIR lodged against the present, my lord, petitioner. Thereafter, my lord, audit was done. Thereafter, my lord, after that audit report is also there. Audit report para 52 enclosed specifically mentioned. After that audit report, my lord, the present FIR is lodged against the present petitioner in pursuance to the direction of the, my lord, Director of Higher Education. So it cannot be said that the allegations are merely on the, my lord, allegations are false. Prima facie, my lord, allegations are, my lord, allegations reflect that such a huge amount deposited in his account. Audit was also done, and thereafter, my lord, this FIR lodged against the present petitioner. So, my lord, from the contents of the FIR, my lord, it seems that he misappropriated his amount of public money.
My lord, my learned friend is right when he reads the FIR. But the manner in which my learned friend is saying, then trial is also not required. I can be sent straight away, my lord, because I am prima facie guilty. But at the end of the day, my lord, I am a professor. Where I'll go, my lord, only saying, you please have this CD. Lordship will consider my health condition. I cannot stand alone, my lord. My wife has to be with me all the time, my lord. My medical condition, my lord. My lord, these are all allegations. I am yet to be proved. My lord, end of the day, my lord, considering the status of a person, my lord, some view can be taken by this honorable court, my lord. Every time, my lord, merely because, kindly see, my lord, had the intention of the person been good, you could have also said, as far as he is also an in-charge principal, he also knows that there is a GB resolution. Why has he not incorporated that in the FIR? Then because, my lord, his case becomes weak. His FIR, my lord, in Dispur, how things are done, we all know, my lord. Somebody must have written some letter. Whenever the word is there, Delhi misappropriated so-and-so, departmental proceeding. But these are all mechanical exercise of power. So all that I'm saying is, my lord, let CDB call. Till then, some protection will be given considering my medical condition at this point.
Mr. K. Chaudhary, Mr. T. also had to be what appearing on behalf of the in connection with this post. It is submitted by Mr. that the present petition that he is an associate professor of the state. He was charged with the fact that he was in charge principal in the relevant period of incident. But he submitted that though the allegation is brought with the FIR that he has no financial power or as a DTO, but was the jurisdiction of the governing body, and he was asked to operate the account of Rusa along with one other, and as per the guideline of the Rusa, RUSA. Also, being a associate professor of the institute, he has there was, but those kind the resolution and authorization of operating account is not incorporated in the FIR, and some false allegations have been brought against the present petition. Further, he submitted that while he was returning from election 15, he made with an accident on 8/5/2024, and out of for which his right side got paralyzed. At present, he is not even in a position to stand alone without any support of the other person. So, considering these aspects of his matter and his present health down status, he may be protected until he may be granted with the privilege of interim prayers so that he can appear and cope with the IO in the investigation. Next paragraph. Mr. Botapu submitted in this regard that there is a allegation of misappropriation of huge amount of money, and from the FIR statement made in the FIR itself, it is said that he misappropriated the money which was deposited in his own account. In his own account, that say that he is not only misappropriating the money fund of the college of the institution, but he also misappropriated the other fund from the college, and thus, considering the nature of the allegation, Mr. Botapu raised objection and submitted that it is not a case to grant the privilege of interim to the present. During the submission on both sides, it is seen that the petitioner produced some documents wherefrom it can be seen that he was authorized by the government body, governing body to operate an account of fund for Rusa, but at the same time there is the election of the distribution of other fund of the body. However, considering the health issues of the present petitioner, who is stated to be paralyzed from his right side, I find it proper to grant the privilege of rearrangement in February. So only considering your health issues,
Miller.
You to fail, cooperate with the investigation and submit it.
Miller, yes, Miller.
Yes.
Deep Miller.
29. 29.
29/8.
29.
Deep Miller.
May I please, Your Lordship?
Yes.
My Lord, almost 60 days I have in custody, my Lordship.
You are in
Below
custody.
commercial commodity.
What nature of case is that? Cases of what nature?
NDPS, my Lordship.
Oh, NDPS.
Almost 60 days in jail, my Lordship. This judgment.
59 days, my lordship. in jail.
How many?
59 days in jail.
9. Yes.
Similar nature, my lordship.
What is it?
My lordship, similar kind of cases, my lordship, on the strength of, on the basis of length of detention, my lordship, bail has been granted.
Yes, Sharma, anything to say?
59 days he was arrested on 24 Lordship.
Yes.
Otherwise, material is there, Lordship.
It's a intermediate quantity.
Yes.
Heard Mr.
SB lordship.
Heard Mr. S.B. Luxford, the London Council for the petition, and also heard Mr. B. Sharma, the London Petitioner BP every month across state. It's an application sequence with it is submitted by Mr. Luxford that the present accused petitioner got arrested in connection with this case on 5/6/2024, and since for 59 days he is in custody, and hence considering his length of detention, he may be enlarged on bail. Next by Mr. Sharma submitted in this regard that this is a case of intermediate quantity of the intermediate quantity. However, he submitted that considering the length of detention, prayer may be considered as till date the IO does not file his he could not furnish the charge. Next, hearing the submission made by the London Council for both sides, and without going on the merit of the case, I find it proper to allow the petitioner to go on bail, considering the length of detention already under contempt. This is from
My lordship, Dalukbari PS, ma'am.
Dalukbari.
So, my lordship, special judge.
And your person is from Kachar.
Yes, my lordship.
50,000 which to the suspected of the Nade racial just Kamrup M. Will be 50,000 with 2 chip.
Highly obliged, my lordship.
20. 20.
May I please, Your Lordship? The Angus Council is on legs. Kindly, matter may adjourn for the day.
Adjournment for the day, Lordship.
You want to adjournment for the day, or it should be a time being?
Adjournment, Your Lordship.
You want an adjournment here?
Yes.
As a request made by the London Council for the matter is adjourned. You have already received, we have, no? The adjourned. However, the scan copy of the has already been received. Next week, it will be listed on 12/8.
Obliged, Your Lordship.
My lord, an unusual prayer, my lord. I'm sorry, my lord, I'm in another court, my lord. Item number 20, my lord. Meter may be taken up now. CD come, my lord. CD is here, my lord.
20, no?
20.
Okay, we'll call.
20, my lord, 88 days today, no? Even 88
It was
days.
earlier called for, in fact. We kept it up at time.
Yeah.
Call.
So, what had application, Lordship? CD has not been received, Lordship.
CD received?
Not received, Lordship.
Are you on interim?
No, my lord. For that may be given.
From where it has to come?
From Goreshwar, Lordship.
Goreswar means
Nearby Hata.
nearby.
We'll try on 9th, Lordship.
Yes, when? That
9/8.
9. Issue reminder 9. We are fixing it on 9.
Same Lordship, CD has not been received. Lordship,
Here also you are not on interim, I think.
not interim. Lordship, last time CD came, Lordship, but the forensic report was not there, so CD was sent back. Yes.
Oh,
This time CD is also not there, Lordship.
last time CD was received.
CD was received. But forensic report was called for along with the
Was
CD, Lordship.
updated for updated case diary.
Yes, Lordship.
Yes, when it can be.
Lordship, let it be on 13/8, Lordship. Lordship, it's too long, Lordship. No protection, Lordship, to me. Well, I am 9th, Lordship.
9th of this month, 9?
9th August, Lordship.
9th. Issue reminder.
Much of it.
Lovely Lordship. The 482 application Lordships. FIR page 9 Lordships.
Try the page 9.
Lordships. Married the affair.
Yes.
With due respect, I have the honor to inform you that my sister, namely Taralik, was married with Ramesh Gogoi, son of Nobin Gogoi of village Kualia Gaon about 1.5 years ago. That today on 31/5/2024 at about 6 p.m. my sister had committed suicide suddenly. The reason of committed suicide is that she was subjected torture for dowry since 6-7 months of her marriage. We also came to know that the accused Ramesh Gogoi asked my sister to bring money from her home and gave on threatening as well as assaulted her after taking drugs. And the accused Srimati Sumitra Gogoi and Krishna Gogoi also tortured her for demand of dowry. As such, I feel that my sister did not commit suicide herself, but the accused persons killed my sister with pre-planned manner and hang in her sleeping room. Though in this regard, I informed the VDP personnel, but they did not take any action, Lordships. Basically, Lordship, election against the husband, Lordship, that is accused number 1. I am not for the accused number 1, Lordships. I am for the 2 and 3, Lordship. The mother of the accused number 1 and brother of the accused number 1, Lordships. That is mother-in-law and brother-in-law of the deceased, Lordships. And Lordship, moreover, Lordship, the accused number 1, who is the main accused, he is already arrested and already released also. He is also released, Lordship, on bail, Lordship. So, my Lord, the mother and the brother and mother-in-law and brother-in-law of the deceased, Lordship, and they are living separately. We are also living separately, Lordship. So, my Lord, bail may be considered on that ground. We don't have any connection with that lady, Lordship. They are living separately. We are also living separately after their marriage, Lordship.
Here, PM report was called for. It has been received, Lordship. Here, no other injuries are there, Lordship, except the ligature mark, Lordship. And it was kept pending for receipt of chemical analysis report. But otherwise, Lordship, there are 2 statements, Lordship, that I would like to place before you, Lordship. Short statement, Lordship. Lordship, kindly go.
He is also an accused.
Yes, Lordship. He was also arrested, Lordship. It appears, Lordship, the victim woman, she was a married lady, Lordship. He had relationship with 2 other men, Lordship. Their statement I have pointed out, Lordship. And it appears, Lordship, one of them, Lordship, had sent some private photograph of the victim to her husband. and Lordship, subsequently there was a quarrel, and out of shame, probably he had committed suicide because there are no other allegation of dowry against the present petitioner. He used to stay in Bangalore. He was here for a short while. That's what I have. Lordship's husband's statement is also there. Lordship. The allegation of against the mother and brother, Lordship, is not there. Lordship.
Part Mr. M. We are on 27. We are on 27. Part Mr. M. Okay, done. Not part Mr. Each property done is the pay on the object response. It's an application of section so and so in connection with so and so. CD received, where is received, hard posted. It is submitted to Mr. Hawk to done it counsel for the petition. That present with the petitioners are mother-in-law and brother-in-law of the deceased, and they are no way connected in the arrest office. They do reside separately, and there is no, and they never demanded any dowry to the deceased. However, they are ready and willing to cooperate with IO in further investigation of this case. He further submitted that they have been falsely implicated in the case without their involvement in the arrest of it. And the prime victim, that the husband of the deceased, is already arrested by police. Next paragraph. Mr. Sharma analyzed that from the materials available in his diary, his case diary, the petitioner, the bearer for the petitioner may be considered as a direction to cooperate the IO in further investigation in this case. Next paragraph. Hearing the submission made by the learned counsel for both sides, I have directly his diary and considering the statement made by the witnesses as well as the co-accused persons, etc., and other material available in the case diary, I find that particular interrogation of the present accused petitioners may not be required for the interest of the investigation, and hence I find it efficient to extend the privilege of free arrest bail to the present accused petitioner. And he provided hearing within 7 days that we are free bail. Okay, you are granted with bail. Appear before the IO within 7 days and cooperate in the investigation. Yes. Mr. Sharma, I did not brought these things in the record because it will be against the morality of a deceased woman. That's
28 Lordship, CD has not been received, Lord. It's from Thubri, Lord.
from
Thubri.
Thubri. None appears on call for the petition. However, it is submitted by Mr. Sharma that CD not yet received. Issue reminder. List the matter at
16-8.
16. 16.
May please, Lordship.
Yes.
438 bail execution, my lord.
Yes.
The petitioner are the mother and son, my lord. About 8 months ago, my lord, one agreement was made that the petitioner one married with the victim deceased, my lord. After 3 months, my lord, they have got the knowledge that the petitioner number one got the knowledge that she has the victim deceased have the love affair with the other boy of that village. That information was given to the parents of the petitioner number one. Then petitioner's parents went to the victim deceased girl that we are not agree to solemnize the marriage, that your daughter is love and affection with the other boy. Well, then after 5 months, my lord, committed suicide in the house of the deceased parents' house, my lord. In this case, my lord, petitioner have no any function, no any.
Let the CD come, Lord. CD has not been received, Lordship.
There is no relation with this matter. Nothing has been done by the petitioner. Petition number one is the boy was intended to marry with this victim deceased, and the petition number two is the mother matter. No formal engagement with that. But allegation brought that kindly page 10 annexure 1 man. Only allegation matter that it is to be marriage with solemnized after 8 months. Man. An allegation brought that they demanded the dowry. They demanded the dowry of, does not arise, my lord. That's because there is no any formal arrangement, no formal engagement and promise to make. So, my lord, petitioner may be allowed to go on bail.
CD has not been received, Lord.
Not received. Oh, I thought it was only received.
Not.
You are submitting, I thought CD received. And we this already called for, let us call for another issue reminder. Yes, when can be
16-8.
16-8.
My lord, the petition number 2 is the mother, my lord.
Let's see, because initially case diary was
at least intimate given to the mother of my lord.
Initially, you have not pressed the things post probably, so it was fixed for CD. Let it be for fixed CD only. No one will arrest you.
Leave
Yes.
May I please, Your Lordship? 438 application, my lord.
Yes.
Earlier CD of CD received.
CD receipt. Okay.
My lord, FIR page number 11, my lord.
Hmm.
My lord,
Yes.
FIR name is number 1, my lord. There is Primakus, my lord. He was arrested and later on he released on regular bail, my lord. My lord, here, my lord, the petition number 4, my lord. Total number of petition 4, my lord. Petition number 1 and 2, my lord, parents of the Primakus, my lord. FIR name is my lord. And 3 and 4, my lord, uncle and aunt, my lord, of the Primakus, my lord. And my lord, page number, and this is page number 17, my lord. There is a forwarding report, my lord. After arresting the Primakus number 1, my lord. There is Ramjan only, my lord. Page number 17, my lord. Annex 2, my lord. Here, my lord, clearly mentioned, my lord. After marriage of their, my lord, petition number, Primakus number 1 and the victim of the, in this, my lord, informant daughter, my lord. They are deciding, my lord, they are residing at a separate place, my lord. From the place of this parents' address, my lord. They are living separate place, that is, my lord, Rangabani, my lord. And this present petitioner, they are residing, my lord, at, my lord, Nilokhia, my lord. There are far difference, my lord. That incident, my lord, was happened, my lord, in the place of Rangabani, my lord. And the present petitioner is residing, my lord, at the Nilokhia place, my lord. For this, my lord, they are not involved in this case, my lord. And petition number 4, my lord, he is not FIR name, my lord. The separate person, my lord. Petition number 4, my lord. It's not FIR name, my lord.
Yes, I can.
Yes, Lordship. Here, Lordship, petitioner number 2, he has already been arrested, Lordship.
Already arrested.
What is that?
Petition number 2.
Yes.
2.
And petitioner number 1, he is the father of the main accused, Lordship, who happens to be the husband of the victim girl, Lordship.
No,
No.
my lord. Petition number 1 is the father of the, my lord, Primakus number 1, my lord.
Okay, that is what I was committing, Lordship. He is the father, Lordship, petitioner number 1. Now, Lordship, what has happened, this victim girl, she belongs to a very poor family. Her parents' statement is also there. This petitioner number 1, Lordship, he got a small girl, Lordship, when she was a minor, Lordship, and brought her to their house, Lordship, with a promise to her mother that he will educate her, and when she grows up, Lordship, she will be married to the son of the petitioner number 1, Lordship. And according to the birth certificate, Lordship, the victim's date of birth is 25/2/2007. Now, Lordship, thereafter, Lordship, the victim girl, Lordship, she was married off to the son of the petitioner number 1, Lordship. Thereafter, Lordship, they were demanding money from dowry from the house of the victim girl. Even a motorcycle was bought by the husband, and the installment was asked to be paid by the mother of the victim girl, Lordship. That is apparent from the witnesses as well as the statement of the informant side, Lordship. Now, Lordship, thereafter, Lordship, on that day, Lordship, she was subjected to cruelty, Lordship. She was beaten up on the date of occurrence, Lordship, because in the PM report, in the section of bruise, position, size, and nature, it is clearly reflected, Lordship, that multiple bruises of size varying from 1 centimeter into 1 centimeter to 1.5 centimeter are present over the right side of face and right side of neck at places and are bluish in color. So apparently, Lordship, she was beaten up, Lordship. Thereafter, she committed suicide or not, Lordship. That report has been kept pending till receipt of the FSL, Lordship. Now, apparently, Lordship, after that, when the information was given to the victim's family that your daughter has died, thereafter they all absconded, Lordship. Every one of the family absconded, Lordship. Now, Lordship, as per the note of the IO, it has come to light, Lordship, that the present petitioners are also trying to obtain the informant's family, Lordship, to take up the case, to withdraw the case, Lordship. That is the material from the case diary. Now, Lordship, as regard petitioner number 2, he has already been arrested, Lordship. Lordship can consider this petitioner number 3, Lordship. After Ali, his involvement appears to be a bit less, Lordship. But otherwise, petition number 1 and 4 are fully involved, Lordship.
Who is 4 in fact?
4, Lordship,
No, how she is related with the deceased?
she is some aunt, Lordship. She lives together there only, Lordship.
No, like, she's an outsider, my lord. Not the family member, my lord. Outsider, my lord. 4 is. Krishna 3 is the uncle and Krishna 4 is the outsider, my lord. A relative person, my lord. And crime because my lord already arrested, my lord, released on bail, my lord. Husband of the victim, my lord.
Khadija Khatun, no, Khadija Khatun. Khadija. I'm sorry, Lordship. I was thinking about petition number 2. 3 and 4, Lordship, can be considered. 2 has already been arrested, Lordship. I was under the impression that Khadija is Khadija, Lordship. So 2 has already been arrested. So all the accusation is against petitioner number 1, up to Samad, father of the husband.
Mr. S. Rahman, Lilan, counsel for the petition, and also Mr. B. Sharma, Lilan, additional KP. This is an application connected with it is submitted by Mr. Rahman, are no way connected in the and the primary accused, that is the husband of the deceased, has already been arrested in connection with this case. The petitioner number 1 are the parents of the prime accused, accused number 1, and 3 and 4 are the uncle and aunt of the accused number 1. They reside separately and they are no way connected with each other. The accused petitioner number 1 and 2 resides in resides a different village, and the deceased and the accused number 1 to reside in this together in the other village. They, however, they are still ready and willing to go to the eye in further investigation of this case if they are granted clearance. No. Clear. Sorry. Next, Sharma submitted in this regard that accused petitioner number 2 has already connected with the case, and hence her petition has already become infectious. He further submitted that considering the matters in the case diary, the prayer for petitioner number 3 and 4 may be considered, who is stated to be the uncle and aunt of the accused number 1. However, he raised strong objection against the accused petitioner number 1, who happens to be the father-in-law of the deceased. Mr. Sharma further submitted that the deceased belonged to very poor family, and she was brought in the house of the accused petitioner number 1 when she was minor, and subsequently she got married with the son of the accused petitioner number 1, and the number 1 first, but thereafter she started demanding money to the deceased, and for which she had to take such a step. And so is there report is there? Like Mr. Magna, you said.
Lordship, PM report is there.
Yes. PM report is available, and as per the PM report, the date is caused due to suicidal. No, opinion is not
Opinion
there.
is not there, Lordship.
That's about the date is not again submitted that they are found like this mark on the neck of the deceased. However, opinion is still pending as the FSL report is not yet received by the eye.
Now, also, Lordship, multiple bruises are there. Multiple bruises on the right side of the.
He further submitted that apart from the glycosyl mark on her neck, there are multiple bruises found on her right side of the neck. Mr. Nick Vera, hearing this submission made by the counsel for both sides and also considering the materials available to the case, this court is of opinion that it is not a big case to extend the privilege of rearrest bail to the present accused petitioner number 1, and at this stage, and the petition has already become structured for the accused petitioner number 2, as he has already been arrested in connection with this case. However, considering the materials, considering the materials in the case therein, I find it a fit case to extend the privilege of rearrest bail to the accused petitioner number 3 and 4. According to okay, 3 and 4 granted bail, anticipatory bail. Try to, cooperate with the IO, appear before the IO within 7 days. Prayer for 1 is rejected, and the prayer for 2 is already become infractious because he has already been arrested.
My lord, in place of 7, my lord, 10 days maybe.
10 days.
10 days.
10 days. Okay.
All right.
Disposed. 1 reject kora hoche, 2 become infractious, 3 and 4.
My lord, only my lord 3 days left, my lord, for mandatory period of 90 days, my lord. I was arrested on my lord on 3/5/2024, my lord. On a complaint, my lord, the learned magistrate, my lord, directed the concerned PS to register a case, my lord. As a result, my lord, the case was registered, and my lord, I was arrested, my lord. I had a laugh affair, my lord. The wife of the affair is at peace, my lord. At page 15, my lord. Para 12, my lord. This is the main allegation, my lord. Para 15, para 12, my lord. Page 15, 1/5.
This is what prior information.
My lord, this is the first information, my lord. Thereafter, my lord, actually, my lord, a case was registered, my lord. When my lord, CR case was filed, that is at page 19, my lord. Page 19, my lord. And my lord, section was, my lord, 42, 366,
My lord, that complaint
73.
petition was later on registered as an FIR, my lord.
My lord.
And lots of 4 pages, my lord, complaint petition. Today is 87 days, my lord. Only on the charge sheet not yet filed. Only
Charge
on the
not
ground
filed, my
of
lord.
claim for detention, my lord. Otherwise,
How many numbers of petitioner? One only.
yes, only one.
One, my lord.
Otherwise, materials is there against the present petitioner.
Part SS Estropa. And the counsel for petitioner and also part Mr. P. Water denied the PP bring on behalf of state respondent. This is an CDDC it is submitted by Mr. Rahman that the present accused petitioner was arrested in connection with this case on 3/5/2024 and since that 7 days he is in custody. But till then, the IO failed to furnish the CS charge it and hence considering the act of detention, his prayer may be considered. However, he is ready and will cooperate in further investigation. Mr. Waterpool submitted in this regard that there are sufficient implementing in the case that, however, considering the length of detention, his prayer may be considered as the IO could not file the charge it within till then. Hearing submitted by the both sides. And without going by the matter of the case, only considering the matter of the detention, the present petitioner is hereby allowed to go on bail for rupees 20,000 with bond security to the satisfaction of where it is pending.
My lord, CJM Hailakandi, my lord.
To the satisfaction of CGM Hailakandi. Okay.
All right.
This time taken after some time, my lord.
No, it has already been. We have already and the earlier in the actually it was called for morning
Basically, my
hung.
lord,
It was called for morning hung. None,
yes.
though none appeared. We just kept it for time being. Now
My
again,
lord,
you cannot time.
yes. My lord, this case initially filed on under section 439, my lord.
No, why I is there?
I is, my lord, correction of cost title, my lord.
Correction of cost item.
Yes, my lord. Although, my lord, there is a judgment for of this honorable court, my lord, that should be 439, my lord. Coordinate bench judgment.
439.
Yes, my lord. Initially, it was filed on 439. Subsequently,
When it was filed.
my lord,
The case was filed when?
file on, my lord, 22nd July, my lord.
22nd of July.
Yes, madam. FIR was
But you have
registered.
filed on under 439.
Yes, madam.
That's why I is there.
Yes.
Anyways, you can submit.
My lord, FIR is, my lord.
So here in this case, FIR is at page 11, my lord. Initially,
Page
my lord, what your lordship may kindly. Here, my lord, one informant has not a
My lord, the
victim lost
petitioner
his-
is the house owner of the guest house, my lord. He is nowhere is connection with this case, my lord. My lord, kindly see FIR in page 11.
Is already in bail. My allegation is I but manufacture later property. how guest house होना है Boarding person है
So you are who are
Petitioner
you?
is the owner of the guest house, my lord.
Petitioner, now the present petitioner is the, my lord, your lordship forwarding report is at page 14, my lord. He is the owner of, my lord, Lovely Guest House.
Guest house, my lord.
And here in the case diary, say, my lord, 164 statement of the, my lord, victim is also available. The allegation against the present petitioners that he allowed those, my lord, accused and the victim to stay in their hotel, my lord, while committing the offense without any documents. So during the stay in the hotel, so the accused person has established physical relationship with the, my lord, victim, and he is the owner of the that guest house. So, my lord, that is the allegation against the present petitioner.
Petitioner has no knowledge, my lord, about
Page
this
14,
incident, my
my
lord.
lord, your lordship may kindly see
He
form number
appointed
4.
the one manager, my lord. The manager is maintained the, my lord, register.
Amal Bhumik बोले ना मैंने अपन को दे
My lord, the name Amal Bhumik is the manager, my lord. He is appointed to him.
Okay, this is the
Yes, and he is in jail from, my lord, 18/7.
18/7.
18/7. Yes.
My lord, I have stated, my lord, submission, my lord, in paragraph number 3, my lord.
You are Mr.
Paragraph number 3, Kolita.
K. Kolkar. Hard Mr. K. What is your case? Don't go by
My lord, my lord, he is
He's not involved.
Yes, sir. Not aware of this fact, my lord. He appointed the manager, my lord, namely Abhinay Bhumik, my lord. Abhinay Bhumik is to maintain the register and other also.
Obinoy?
Abhinay Bhumik, my lord. I have stated in paragraph 3, my lord.
Hard Mr. K. Kolkar, that comes with the petition. Also, hard Mr. report that it will not be published. This is an application that it's it is submitted by Mr. Kalita that the present petitioner is innocent and he is no way connected to the arrest of us. It is the fact that he is the owner of the state guest house, but the state guest was run by one Abhinay Bhumik, his manager. And thus, he is not aware about if any illegal activity taken place in his group. However, he was arrested in connection with this case on 18/7/2024, and hence considering his lack of detention also he may be advised on bail. Next, where Mr. Water Petition BP submitted in this regard that from the materials of the case diary, that he is the owner of the guest house and some illegal activities were going on in post of his allegation against the present accused petitioner is that he used to give the his guest house to the person without verifying any documents, and thus he was helping in running the illegal activities. Considering the sufficient getting the submission made by the article, I have also been about a case diary, and considering the documents available in the case diary, I find that further interrogation of the present may not be necessary for the interest of the investigation, and hence I find it difficult to extend the privilege of bail to present accused petitioner. It is case of Borolomuk. Kambuk XTGM Kambuk. They dispose of Borolomuk. And 47 also dispose of Borolomuk. 47 which said hard to answer Mr. Kolita. This is an
subsequently it is
for correction of the proper provision for correction of the cost of the petition, full stop, is wherein inadvertently the 439 CRPC has been where inadvertently 439 where inadvertently the application was made under section 439 CRPC instead of 483 of BNSS 2023. Accordingly, he paid for correction of the cost guide of the in the BA application, BA number 2137. Mr. Botapur is no objection that. Accordingly, prayer allowed. Lady said the BA application number 2137 2020 will be read as application under section 483 of BNSS. With the above observation, I send. I is disposed of and your other petition is also allowed. No, he is.
Mate,
This was part heard, I think.
yes, my lord, this is part heard, my lord. The Lordship has called for the records, scan copy of the case diary as well as the records of this case, my lord, from the court below.
Not at all. Only we have received the scan copy. Some portions are not properly legible, but yes, it can be.
My lord, I'll just to refresh your Lordship mind, my lord. What has happened in this case, there are 3 FIRs arising of the same one offense, my lord. One FIR has been quashed by this honorable court, and 2 affairs, one by me, my lord, and one by employee of the company, the Sunrise Biscuit Factory, my lord. Both of them, in both the cases, my lord, FIR resulting to 2 separate charge sheets, my lord. One has been accused, in one case, I've been charged as an accused, and my cases, the complainant has been, my lord, the complainant here is made a accused there, my lord. Now I'm challenging the charge sheet, my lord, which is against me, my lord. If your Lordship will kindly see the FIR first, my lord. I just come to the FIR first. Lordship will find the page 22. I'm sorry, 20.
28.
20 is my FIR, my lord.
It's your FIR.
My FIR, my lord.
22 is the
My lord.
another FIR is it?
Is, my lord, which is under challenge, my lord. Your Lordship will find that is by the at page 22, my lord. 22, my lord. That is by the fire officer, my lord. That is by the fire officer, my lord.
FIR by the fire officer.
Fire officer, my lord. Your Lordship, kindly go through that FIR, my lord, page 22, my lord. Now, what is it? With due respect, would like to inform you that on so-and-so at about 2:45 a.m. I received an information that the fire broke out at Sunrise Biscuit Factory, Borgaon, from the Fire and Emergency Service. After receiving the information, I, along with the fire personnel of Lokra Fire and Emergency Service with 2 numbers of water tank, went to the place of occurrence. After reaching the place of occurrence, I found that the workers of Sunrise Biscuit Factory have already put out the fire. After inspection of the site, it was found that 2,000-3,000 numbers of the empty carton were lying beside the machines present in the factory, and some part of those empty cartons caught fire, while in the meantime the workers of the factory would put off the said fire. As there was no eyewitness, it is very important because there are no eyewitness of the occurrence. As such, reason behind the incident of the fire could not be known. Within a few distance of the place of occurrence, there was a generator and the surrounding of the said generator. Lots of diesel was scattered and matchstick were found lying. Be it noted, on 19/6/2000, about a fire broke out and at the godown of the same factory. After 15-20 minutes of the incident, another fire broke out at the same place and it took 40 years to put off the fire. On investigation of the incident, written statement of the two workers, my lord, factory were received, which enclosed Amol Saloy and Borun Pandey. My lord, this is very important. Why I just stress on these two names, because I will come to later on, my lord. Amol Saloy and Borun Pandey, my lord. All the fire incident of the above factory took place at the night of so-and-so, dated so-and-so, so-and-so, on the basis of the pattern of the fire as well as on the basis of the statement recorded from the factory workers. There are reason of suspicion, my lord. Your lordship kindly said reason of suspicion. And it might believe that this two incident has happened as a result of conspiracy. Therefore, I pray before the honor to take investigation in the so-and-so, so-and-so. Well, in this case, my lord, investigation done and searches has been filed regarding the manager. I am the manager of the company, my lord. Sunrise Biscuit Factory is a subsidiary, my lord, of Britannia Industries, my lord. Now, your lordship will find the development. What is the development your lordship will find? Your lordship will kindly, page 32, my lord, your lordship may kindly take this. Now, what they have stated to the official answers, Gorchuk Police Station, in that there are a lot of valuable property, so-and-so, fire broke out at the factory premises. In the result, lot of valuable property destroyed and relation of the...
This is also another affair.
My lord, yes, my lord, Louis Das. It was quashed, my lord.
It has already been
Quashed by this honorable court, because the same incident, 3 FIRs, my lord, 3-4 FIRs, my lord. It has been quashed, my lord. Now, your lordship will find, this is very important, my lord. Now, Lohit Das, my lord, who has given that the FIR, which he has filed, my lord, Lohit Das, he has wrote a letter to the investigating officer at Annexure 5, that is at page 38, my lord. What he said, your lordship will kindly say, I wish to take an opportunity to put forth before the true fact that I believe have not come so far on record due to the monumental misunderstanding and action in patient during the heat of the moment. I made some statement before you and other past assuming that be true, but now when I introspect our conduct and look back at every incident that took place in the SBCL premises located at Boragaon on the intervening night between 23rd and 24th July, I found that all the management team led by Rajan so-and-so was trying to do so, find the real cause of fire, so that such incident could be stopped forever, since the fire accident had taken place in past 20 and 20 June as well. When I put things in perspective, I realized that at no point of time Umesh Das voluntarily admitted to set factory on the fire basis any allurement, leave aside any promise from the factory manager. It seems that he said what was told by the angry mob who took him along with us to the factory manager's office, where the management was about to start his investigation and trying to understand the cause of the fire. However, due to the unrest and subsequent development thereafter, it could not be concluded. I sincerely regret the statement made by me in the heat of the moment, and thereafter I, under the provocation, holding people responsible for the action. I have no direct and constructive knowledge of the statement made by me before your good chief and subsequently before other persons have been made on the hearsay statement, my lord. The lordship will kindly see these are the statements on the basis of which these all are hearsay, my lord. I'll come to the later on, my lord. That is Lohit Das, who was also an informant in that incident, my lord. That subsequently it has been caused, that's a different thing. But your lordship has to take in as a whole the statement what the other workers are saying, my lord, regarding this case, my lord. Now, again, page 40, my lord. Your lordship will kindly see the workers has come because there's a FIR, 2 FIRs. because one FIR I filed, then what has happened? The police, the fire officer come. In the fire officer, he said that there is a suspicion how it has been happened. Then he took statement. The workers has said that it may be because of this at the instruction of Rajan Kumar, the petitioner here. It was been put on fire at the heated moment of. But what they said is, if your lordship kindly see, I have gone through the 161 statement also. All are hearsay only, my lord. Now what they say is now to the police, my lord, investigative officer, my lord, what they say. That is at Annexure 6, page 40, my lord. We wish to take this opportunity to put forward before you that the true fact that we believe have not come so far on record due to the monumental misunderstanding and action in patient during the heat of the moment. We made some statement before you and other in the past, assuming them to be true. But now when we introspect our conduct and look back at the every incident that took place in the SBCL premises located at Boragaon on the intervening night between 23rd and 24th July, we find that all management team led by Rajan Kumar, then factory manager, was trying to do so to find the real cause of fire, so that such incident could be stopped forever. Since a fire accident has taken places in past 2020 as well as, when we put things in perspective, we realize that at no point did Umesh Das voluntarily admitted to set factory on fire on the basis of the alone-man leave aside any promise from the factory manager. It says that the Umesh Das has put on fire at the instruction of me, Mila. And that is the FIR. It seems that it said that what he was told by the angry mob who took him along with us to factory manager office, the management was about to start its investigation and trying to understand the cause of the fire. However, due to unrest and subsequent development, therefore, it could not be concluded. We sincerely regret the statement made by me in the heat of the moment and thereafter under the provocation holding the people responsible for action we have no direct or constructive knowledge of. The statement by me before your good self and subsequent before other persons have been made on the hearsay statement that we are being made generic angry move which are assumed to be true. Well, these are the person, Miller, who has signed, Miller. Kindly see the 15%, one of which Sadaram Das was also having a statement has been recorded, Miller, by the police, Miller. And the police has received it, Miller. You will kindly see the endorsement of the police at page 40, Miller, the endorsement of the letter which has been received by the IO and the police department, Miller. The Gorchu police station. There's an endorsement received of acknowledging the receipt of this letter, Miller. That is at page 40, Miller. Now your lordship in Kalisi, because there is a dispute between the workers and the management. Now management has come with its solutions. Accordingly, what has happened, my lord, that we have dismissed some workers from this. So that resulted in a hue and cry between the workers, my lord. Now thereafter, what it was happened, they have pointed out that it is because of him. Now when we come to a conclusion and where there have been understanding between us, my lord, this has happened, my lord, kindly see. The workers which we have, my lord, give voluntary retirement and dismiss from the work, my lord. Then we have given the money, and along with these things, they have acknowledged, but there's a, my lord, settlement, and out of the settlement, my lord, your lordship will find that is at Annexure 7, page 42 onwards, my lord, the settlement between so and so, my lord. So will not, my lord, come all these things, my lord. There is a settlement between, and it is the settlement agreement which we have enclosed from page 43 onwards to, my lord, 51, my lord. Now, this is the charge sheet which is under challenge, my lord. Page 52, it starts, my lord. Not page 52, it starts, my lord. who is Ramesh Chandra Kolita, that is the fire officer, my lord. Now, against me, what? Ramesh Chandra Barik and my lord Umesh Chandra, Rajan Kumar Barik and Umesh Das, my lord. So, what it says, the success have been submitted under section 120B, 436 and 34, my lord. And what is the conclusion of an investigating officer? That during the course of investigations, they find prima facie materials against us. So accordingly, they have submitted the charge sheet. Now, what is the prima facie materials they found? That is in 161 statement. And what are the statement which has been given by the employees, my lord? Kindly see, I have made a list of the 161 statement while I go through, my lord. Borun Pandey, he has said that he is also the hearsay. Amol Saloy, hearsay. Ramesh Kolita is an informant. He is an informant. Deepak Kumar Nath is an hearsay only. Sadhan Das is an hearsay only. Sadhan Das is between a compromise. They come to a compromise at page 40. Sadaram Das. I am sorry, my lord. Biseswar Das, my lord, hearsay. There's another Deep Duty Das is also, that statement is not with us. The Subara Deep Duty Das is concerned, my lord. Amol Das, my lord, your lord, Amol Saloy, my lord, your lordship, I'll show Amol Saloy, Borun Pandey. These are the person on the basis of which the entire case is set in motion, my lord. Now, Annexure 9, my lord, just a minute, my lord, I'll just show you the third FIR, my lord. First, second, third, my lord. First, my mean, then then another by Umesh Das, my lord, who has come also said that out of heated actions we have said it. That was, my lord, by order dated 13/3/2019, that has been quashed, my lord. That FIR, my lord. There cannot be multiple FIRs on the same incident, my lord. The law is subtle, my lord. Now, your lordship will kindly see that next is, my lord, the charge sheet which I filed the cover of, that is at page 61, my lord. Page 61, my lord. Which is also my Ranjan Kumar Barik, the petitioner here in my lord, which I am an accused, my lord. Here, I am the complainant, my lord. There. And who are the accused there, my lord? Umesh Das. Huh? Umesh Das is also accused there. Here also accused, my lord. Umesh Das. Then Nobo Kumar Bormon, my lord. Bhuvan Chandra Das, Sadaram Das, my lord. Also, my lord. Those the employees who say that we have so and so, my lord. And now, my lord, your lordship will kindly see Amol Saloy, my lord. Your lordship will kindly. Page 71, your lordship may kindly take 71, my lord. The Amol Saloy, Amar Tajikon. Annexure 11, my lord, your lordship got the 71. Amol Saloy, my lord, what has happened? The workers has gone there, my lord, to give statement that we have not said so. The police has not received one. They said that no, I will not take your statement, my lord. So we have, by written, we have sent it through registered post to the police station, my lord. That is the copy which I have enclosed along with the, my lord, the receipt, my lord, of the register. Well, what it says, kindly see, Your Lordship will find everything here. Annexure 11 to the investigation, remarkable, FIR number so and so, that is where the charges has been filed against us, this 397 million. Then 398 is, my lord, by where the others, Umesh Das was also made an accused where I am the complainant. And 401 has been, my lord, quashed by the Honorable Court. 3 affairs. The laws above mentioned Gorsuk Police regarding fire incident Sunrise Biscuit Factory. I would like to take the opportunity to reveal the whole truth before you, which may not be recorded. I gave my statement regarding fire incident of 19 June so-and-so, dated so-and-so. As far I remember that the said fire incident occurred due to the electric short circuit, but at that time, the investigation was going on. After this, on dated so-and-so, another fire incident took place with the company premises on the night of 23rd July. I was not on duty and joined my duty on 24th July during morning time, and then only came to know about the incident of fire. I never deposed any kind of statement before any officer, or no one had ever asked me. I would like to inform you that I never deposed any statement before any fire brigade officer or any police officer, as I was not present at the time of incident, Miller. Well, it is very important. Kindly see, the copy has been given to the investigating officer, HSO Gorsuk Police, Sunrise Biscuit so-and-so, and Ranjan Barik, Miller. Now, if your Lordship kindly see the FIR of that, which is against us, what it says, that Amal Saloy and so Das, they, on the basis of their statement, Miller, they lost this FIR. Because when he gone there, Miller, he did not find any eyewitness to that. Then he started, he has a suspicion. They said, then thereafter he asked 2-3%, and these 2-3% say, they are the hearsay only. What he said, that hearsay only, that this is happened. Now, in nutshell, Miller, this is the fact of the case. Now, the law point involved in this case, Miller, that whether two searches, Miller, of the same affairs goes together or not, Miller, where one has been made an accused and where I haven't made it a complaint, Miller. That is the question before the court, which a Lordship has to determine, and Lordship has to look into it. Same set of, my lord, it will not resulted to the conviction on the face of it, my lord. On the face of it, my lord, assuming if a Lordship allowed, my lord, reject this petition and trial should be commenced, my lord. Whether this, the statement which has been under 161 statement which has been provided to us, my lord, if your Lordship take in the face value of 161 statement, because apart from the other 161, they cannot go travel beyond that, my lord. Whatever he stated in 160, he will say the same thing in the so and so. Now, all the statements are hearsay, my lord. On the hearsay, can a conviction be made, my lord? And trial, if this goes also, it will be absolutely abuse process of law. Now, if your Lordship see, they have come before the police officer, they have stated that because of my lord, angry and out of a heated exchange of words, but they have stated like this. What they have said, nobody has said that they have seen that so-and-so Mananda Das has put on fire at the instruction. They said that we hear. We came to know, we hear. One has said from the TV I came to know. One said that I just hear they said so-and-so, so-and-so. Now, your Lordship, while exercising power under 482, Miller, whether the materials which an accused here in Miller, the evidences which has been given taken into the consideration by the court or not while exercising power under 482, Miller. Now, I'll just, the law point which involved Miller, okay. Oh, I'm sorry, before that, I'll just, Miller, the complainant has also been made a party because they have filed an affidavit. Now, what they said, Miller, kindly see their affidavit, Miller. That is also, your Lordship has to take into the consideration of their affidavit also, that because I have to Ramesh Chandra Kolita, There's a fire officer, my lord. He's the fire officer, the informant, my lord.
Where is the page number?
My lord, the affidavit which has been filed by affidavit 70.
Yes.
Your lordship got it. No? Now, what he says, my lord, if your lordship kindly see the informant, the affidavit on oath, my lord, what he says. The paragraph 5, they say, with regard to the statement made in paragraph so and so criminal, the deponent begs to state that on 24/7/2016 at about 2:45 a.m., the deponent received an information from the fire and emergency service that a fire broke out at the premises of Sunrise Biscuit Factory, Borgaon. After receiving such information, the deponent, being the station officer of the Lokra fire and emergency stations, rushed to the place of occurrence along with the other fire personnel. After reaching the places, the deponent noticed that the workers of the said factory have already put off the fire. After inspection of the site, it was found that 2,000-3,000 numbers of empty curtains were lying beside the machines present at the factory, and some part of those empty curtains caught fire. While in the meantime, the workers of the factory would put off the said fire. It was further noticed that a few distance from the place of occurrence, there was a generator and surrounding the said generator, lots of diesel was scattered and matchstick were found lying. It is pertinent to mention herein that from the person present at the place of occurrence, the deponent has also come to know that on so-and-so, 19/6 about so-and-so, as well as 20/so about so-and-so, similar fire broke out at the same place, and it took 48 hours to put off the fire. During the investigation of the incident occurred on 24/7/2016, the deponent recorded the stated manner. Kindly see the Amal Saloy and Borun Pandey, both of the signatory that they have not said anything to so and so. On the basis of such statement of the said workers, as well as considering the pattern of the fire, this is very important, your lordship, what he has said on oath, my lord. On the basis of the such statement, that is two, Amal Saloy and Borun Pandey, my lord. Lordship, kindly take note of this two persons. The said workers, as well as considering the pattern of the fire, the instant deponent so-and-so lost an FIR. He lost an FIR on the basis of so-and-so. And the pattern of the fire, how he assess, I do not know, my lord. God's pollution by stating that above incident, as stated above, may happen. My lord, may had happened as a result of conspiracy. May had happened. In the criminal jurisprudence, my lord, the question of may, this doesn't come. Well, it shall be. It has to be, my lord, definite and concrete, my lord. For which the deponent requested the police to make an investigation. Then I'll skip all the statements. I'll come the last, that is at paragraph 12, my lord. That is nothing. These are only things that so-and-so, so-and-so. 12 is that with regard to the statement made in paragraph 15 of the criminal petition, the deponent begs to state that the FIR data was lost on the basis of the statement of two workers, namely Amal Saloy and Borun Pandey, also the nature of the incident and the pattern of the fire occurred on so-and-so and so-and-so. The FIR was lost on a suspicion that all incident occurred on so-and-so and may happen as a result of conspiracy. My lord, kindly see that what he said, the deponent had no knowledge about the change of the statement made of the two workers subsequently during the investigation. Further, the deponent has no knowledge about the later dated so-and-so communicated to Amal Saloy by Sri Amal Saloy to the investigation. How? Because he will not definitely know about this thing, the letter which has been sent to the police, Miller, because the police has been investigating, Miller. Now, from the affidavit of the complainant, the informant, Miller, your lordship will find this FIR was lost on the basis of and hearsay evidence, Miller, that is Amal Saloy and Borun Pandey, Miller. These two persons, Miller. And secondly, because earlier there is a fire, Miller, he had a suspicion, Miller, there may be a conspiracy. So the question of maybe, Miller, how it can be, Miller? You cannot, on the basis of the suspicion, you cannot file a FIR, Miller. You have to be specific that I have gone there and I found these are the two persons. They said that so and so has done so and so, and accordingly I have filed and I have investigated also. I found so and so, my lord. That should be, my lord. Now regarding, my lord, my lord, now question of law, my lord. Regarding, my lord, that the defense, my lord, now I'm an accused, my lord. What I have been produced before lordship for in support of my defense, my lord, can your lordship consider it while exercising power under 482 or not, my lord? Earlier it was not, my lord. Now the apex court has said that no, that can be relied on, is taken to be face value for the purpose of defense. Your lordship will kindly, I have placed the judgments of, my lord, which is reported at 2013 3 SSC, my lord, and your lordship straightway go to the paragraph 27, my lord. Paragraph 27, my lord. Now what it says, recently, I just read out, my lord. Recently, this court again had an occasion to examine the ambit and the scope of 482 CRPC in so and so, wherein this matter, the main order was being observed that wide of the power of the High Court under 482 and under 226 of the Constitution was unlimited. The said judgment, the court held that the High Court could make such orders as may be necessary to prevent the abuse process of any court or otherwise to secure the end of the justice. In a concurring separate order passed in the same case, it was additionally observed that under section 482 CRPC, the High Court was free to consider even materials that may be produced on behalf of the accused to arrive at a decision whether the charge as framed could be maintained. The aforesaid parameter shall be kept in mind while we examine whether the High Court ought to have exercised inherited jurisdiction under 482 in the facts and circumstances of this cases, my lord. Now, paragraph 29, I skip to paragraph 29, my lord. So thereby, this has been stated that while considering whether the abuse process of law or not, that materials which an accused has been produced in his defense, my lord, that can be considered under 482, my lord, which your lordship will find in my cases where I have places the letters which has been sent by Amal Saloy and others that they have not saying so and so, my lord. Now, if your lordship kindly see paragraph 29 of that, my lord, the issue, paragraph 29, my lord, the issue being examined in the instant case, its jurisdiction of the High Court under section 482 CRPC, if it is used to quash the initiation of the prosecution against an accused at the stage of issuing process or at the stage of committal or even at the stage of framing a charge. These are all stages before commencement of the actual trial. The same parameters would naturally be available for later stages as well as the power vested in the High Court under 482 at the stage referred to herein above would have far-reaching consequences in as much as it would be negate the prosecution complaint case without allowing prosecution complaint to lead evidences. Such a determination must always be rendered with caution, care, and circumspections. To invoke its inherent jurisdiction under section 482 CRPC, High Court has to fully satisfied that the material produced by the accused is such that would lead to a conclusion that his defense is based on sound, reasonable, and undisputed facts. The materials produced is such as would rule out a displace and assertions contained in the search level against this accused, and the material produced is such would clearly reject and overrule the veracity of the allegations contained in the accusation level of the prosecution complaint. It should be sufficient to rule out, the reject and discard the accusations leveled by the prosecution complaint without necessity of recording any evidence for these materials relied upon the defense should not be refuted or alternatively cannot be justifiably refuted, being material of sterling and impeachable quality. The material relied upon by the accused should be such as would presume the reasonable person to dismiss the condemn and the actual basis of the acquisition is false. In such situation, the judicial conscience of the High Court would persuade it to exercise its power under 482 to quash the such criminal proceeding for would prevent the abuse process of the court and secure the ends of the justice, my lord. So basically, this paragraph says that these are the factors that should be reliable, whatever this thing. And now, if your lordship kindly see, in my cases, the statement of the witnesses, number one, which are in 161, are all hearsay, that is number one. And, my lord, the complainant from where the entire case was set in motion, my lord, by Amol Saloy and, my lord, Borun Pandey, has said that we have never give such type of statement, my lord. So definitely, my lord, and the letter which has been, my lord, they have sent it, that has been endorsed, that the list, the 15%, Sadananda Das also, where they have endorsed, the police has received and endorsed the receipt of the same, my lord. They acknowledge the receipt of the same option. That is, secondly, my lord, the letter which has been sent, that is by registered post, my lord. By registered post, which I enclose the copy of the receipt of the registered post, my lord, which were enclosed, my lord, 75 onwards, my lord. 75. Counter so-and-so, SHO, Godsuk, where everything is there, my lord. That's the register. So now, my lord, the first point, my first leg of agreement regarding, my lord, whether the defense evidences, my lord, can be taken for the purpose of, my lord, considering the entire cases under section 482 or not. That is number one. Now, secondly, my lord, so, my lord, there are now two search of the same offense, my lord. There is an rightly, wrongly, there is an FIR. My lord, sorry, fire, my lord. Fire has been there, that is not disputed. On 24/7/2014, there is a fire, my lord. Prior to that, there's another fire, my lord, which has not come to the stage. Now, and the FIR is of 24/7. There's an FIR. Now, the question is 434, how 434 will come against us, my lord? Because there is 34 is there, 120B is there. 120B is again. Huh? 436, 120B. Now, 120B. Well, kindly see what 120B is. There's a conspiracy, my lord. Going to the main, that is 436. First of all, the prosecution has to prove, so the conspiracy is concerned, 120B. Then only they can go. Now they have to show the prima facie, my lord. What prima facie means, my lord? At the first sight, my lord. If there is something against me, my lord, at the first sight, the prima facie is what, my lord? At the first sight, my lord, if you go by the definition of the prima facie, my lord, what prima facie says, that at the first sight, if there is something against me or there is something, my lord, that is a prima facie, the materials available so and so. Now here 120B, there has to be, number one, the prima facie case to mean out to make my lord, charge against me of the same. And the statement of these things are there, my lord. A list condition, what are statements? 160, Borun Pandey, Amol Saloy, Ramesh Kolita, Dipankar Nath, Sadhan Das, Bireswar Das, and Sadaram Das, and Visheswar Das, my lord. I just 161, my lord. I'll just come to the Borun Pandey, my lord. This is Borun Pandey, my lord. What it says, my lord? Kindly see, মোৰ নাম বৰুণ পাণ্ডে, মই চেন্নাই বিশ্ব কোম্পানী সোয়েঞ্চো পূবে কোম্পানীটোত অফিচাৰ প্ৰায় ইমান বছৰ কাম কৰি আছো। যোৱা ইমান তাৰিখে মই কেজুৱেলৰ 5জন ল'ৰাসকলে কোম্পানীত বিস্কুট ফেক্টৰীত কৰি আছিলোঁ। নিশা ইমান বজাত কৰি থোৱা বিস্কুটৰ বস্তা ধোৱা পৰিচিত কৰোঁ। লগে লগে আমি 5টা অমুক হাইড্ৰেণ্ডৰ সহায়ত জুই নুমুৱা। তাৰপিছত আমি ঠাইখিনি চাফ চিকুণ কৰি অৱস্থাত মুঠতে আমি থকা স্থানৰ পৰা প্ৰায় 20-25 ফুট দূৰত ডাঙৰলে জুই থকা পৰিলক্ষিত কৰোঁ। সেই ঠাইখিনিতে নুমুৱা ৰাস্তা নাছিল। অলপ দূৰত এটা এণ্ট্ৰি আছিল, যদিও সেইটো বাহিৰৰ পৰা তললৈ লগোৱা আছিল। ভিতৰৰ ফালে অহা যোৱা পথত বস্তু দমাই থোৱা আছিল। লগে লগে কোম্পানীৰ ছিকিউৰিটি চাৰ্জ টেম্পৰি থকা অমল খালৈ নিজৰ ব্যক্তিগত নম্বৰ ইমানৰ পৰা ইমান ফোন কৰি জুই লগাৰ সংবাদ ষ্টেট অমুক দিয়ে। নিশা প্ৰায় 6:30 বজাত গাড়ী আহি অগ্নিবিভাগ ভ্ৰমণ কৰে। প্ৰথমতে জুই পৰিলক্ষ্য কৰা ঠাইত এখন ইলেক্ট্ৰিকেল পেনেল আছিল। মোৰ ফালৰ পৰা জুই লগাৰ কোনো বিশেষ কাৰণ জানিব পৰা হোৱা নাই। কেজুৱেল কাম কৰা 5জন এমপ্লয়ী দেৱজ্যোতি কথা প্ৰথম জুই লগা দেখা পায়। তপন দাস, কুশল কলিতা, নন্দেশ্বৰ দাস, অৱনী চন্দ্ৰ কলিতা। Here, okay? Oh, nice. Nothing. So here nothing, my lord, as is being. So my respectful submission, my lord, is this, my lord, is a case, my lord, where lordship can exercise the power under section 483 for abuse process of suppose and the other which has been I filed, my lord, that was registered at 143-436. The same 436 is the same. 448, 342, 291, 506, 34, my lord. Suppose anything come in this case also, my lord, in my case, anything comes out, my lord, the court has power to make me accused, my lord, if anything comes, my lord. Now, in one cases, now whether that 2 parallel proceeding can go in the same offense, my lord. My respectful submission is no, my lord. Oh, and my lord, I just conclude, my lord.
Last occasion also, 71. Last occasion also you submitted all this, about the declaration of Amal Saloi, the charges regarding all this.
My lord?
On the last occasion also you have submitted all these things. I have already noted down.
My lord, yes. So far the facts is concerned, nothing. So far the law is concerned, well, just 2-3 judgment I'll cite it. Thereafter I will not cite it anything. Okay, my lord. I'll conclude it within 5 minutes. Right. That is regarding this reported in 2021, my lord, 5 SCC 524. I'll come to straightway paragraph 17, my lord. I'll not go to the facts of the case, my lord. Come to the now, there are also same set of allegations, my lord. That is 210 CRPC has been discussed with, my lord. Now, paragraph 17, what it says, my lord, does merely because on the same of the facts with the same allegations above earlier complaint, there is no bar to lodge an FIR, my lord. There is no bar, my lord. What it says with the police stations with the same allegation and so and so. However, at the same time, if it is found that the subsequent FIR is an abuse process of law and the same has been lost only to harass the accused, the same can be quashed in excess power under 226 of the Constitution of the exercise power under 482. In that case, the complaint case will be proceeded further in accordance with provision of CRPC. What has happened in this case? There are the complaint cases which has been, and there is a police case below. There's 2 below. So the provision of 2, that 210 is what? That when there are 2 cases, one is complaint case and so, one has to be stayed below. This now what is said that if the second FIR is abuse of a law, it say that it can be quashed below. Now, as observed and held by the court in a catena decision in head jurisdiction under section 482 and under 220 of the Constitution as designated to achieve the statutory purpose of the criminal proceeding ought not to be permitted to degenerate into the weapon of harassment when the court is satisfied the criminal process amount to a abuse process of law, or that amounts to bringing pressure upon the accused in exercise of inherited powers, such procedure can be quashed, my lord. So that is the another, my lord. I'll just come to your case. Paragraph 16, my lord, if you lordship anything. It's regarding, my lord, the excess of power for discharging a recused, scope and ambit of the power of the trial court under 227, my lord. Now, paragraph 16, it says that it is cited that the word not sufficient ground for proceeding against the recused appearing to be a section postulate the exercise of judicial mind on the part of a judge of the fact of the to the fact of the case in order to determine whether a case of a trial has been made out by the prosecution. However, in assessing the fact, the judge has to have power to sift and weigh the material for the purpose of the finding the whether or not prima facie case against the accused has been made out. The test of the determined prima facie case depend upon the facts of the each cases in this regard. It is neither the feasible nor desirable to lay down the rule of individual applications by and large. However, if two views are equally possible and the judge is satisfied that the evidence produced before him gives rise suspicion only the distinguished from the grave suspicion, he will be fully within his right to discharge the accused. At this stage, he has not to see the whether the trial will end with conviction or not, my lord. This is very important, my lord. Now, if there is two views possible, my lord, and there are that whether it will be in with a conviction or discharge, he'll have if there is some materials, the lordship can exercise the power and authority to my lord, discharge this accused and watch this, my lord. That's what I just pointed out before your lordship, that number one, the FIR which is set in motion, the entire case is set in motion on the basis of a hearsay, that is number one. Secondly, both of the person, what it stated, the two person, Amal Salo and so and so, on the basis of which they have stated before the police that these are we have not given so and so. So same thing they will come here also, my lord. They will come here also and say that fine, that whether it is amount to leading to a conviction or not, my lord. It will be absolutely abuse process of law, my lord. And secondly, no one has said that so and so doing so and so, my lord. And secondly, my lord, and so far, my lord, I am concerned, my lord. There are two accused. One is Sadananda Das and myself, my lord. Umesh Das. Umesh Das has not come for, my lord. My lord, another case is, my lord, I'll just you go ahead. 1988. 1988 to 9 again. Okay. 1980. I don't have the, my lord. I just slowly for paragraph 7, my lord, lordship, 1 o'clock. Can I continue at 2? Just 2 minutes, 5 minutes, my lord. I have to show that.
Okay. You want to show that?
No, if your lordship want to rise, my lord, I'll continue at 2 o'clock. It will take only 5 minutes, my lord. Or if you,
First of all, 2 o'clock, 3 VCs are there.
my lord.
So after completion of 3 VCs, this will be hard.
Some other date may be fixed.
No, it will be completed. This is nothing. Just your lordship, your lordship may kindly take.
So at 2 it will be hard, but
Yes.
after completion of 3 VC only.
Yes.
Then it can be hard, and one more matter is also there.
My
So it will be continued.
my lord.
Your part will be hard after the completion. So this will be most likely connected at 2, sharp at 2. So that's why up thereafter will be there.
I have only 5 minutes. my lord.
Only 600. Election petition is based on the grounds that is your lordship will get it at page 65. Grounds are mainly, my lord, corrupt practice of undue, page 65, I'm sorry. Grounds are basically, it's a corrupt practice of undue influence, boot capturing, and improper acceptance of nomination paper. These are the grounds which are mentioned in section 100 of the RP Act. And at page 72 is the prayer, and material facts and particulars regarding undue influence is at page 19. Material facts and particulars as required under section 83 of the RP Act. And as regards the boot capturing, the material facts and particulars are at page 33. On the basis of these facts and particulars and on the grounds contemplated under section 81 of the RP Act, we have made a prayer at page 72.
So basically, boot capturing, undue influence is
Undue influence and boot capturing at page 33. Undue influence at page 19. Boot capturing at page 33. Regarding the material facts. The grounds are also on that, in that line. Grounds are mentioned at page 66. Because of these corrupt practices committed by the respondent, he could win the election with a margin of only 630.
okay, yes.
My lord.
Mr. KP Pat, Mr. Opat, and Nick. Nalo, no? And Pat, the council for this is the application. This is the election required under section 8. Read with section 80A of the Legislative of People's Act 1991, represented under section 81 of the Act. It is submitted by Mr. Pathak, the senior advocate, that the case has been the elected petition has been lodged against the good practice of corrupt practice of anti-religion as well as good capturing, and which were and the grounds were accordingly mentioned in the but considering the sufficient notice, the respondents to register in an advocate process. We are also allowing you the process to dusty mode.
Registered post as well as dusty mode.
That's it. So this you want any fix it here also?
My lord.
Yesterday, I have given you one.
Yes, my lord, that is on 21st of August.
Yes.
On the same date, it may be also fixed, my lord. 21st of August.
Same day may be difficult. Let
My
it be
lord.
22nd then? 22nd of August?
My lord.
Okay.
That will also do. Obliged, your lordship. Switch off. This one.
Yes, Mr. Kato?
My lord,
Yes.
this is, may I submit, my lord? My lord, this is also election petition filed under section 80 and 180A and 81 of the People's Representation Act, my lord. My lord, on the grounds that the returned candidate, my lord, the sole respondent herein, has not disclosed the material facts in his affidavit, my lord. So this is amounting to a corrupt practice, my lord, and as per the form, my lord, the format provided by the election, the affidavit, wherein the non-disclosure of the material facts is given, my lord. So therefore, my lord, may I take your lordships to the, my lord, the particular paragraph and the relevant provisions where, my lord, the corrupt practice has been done. Page number, my lord, 53, my lord, of my election petition, my lord. Page number 53, my lord.
Yes.
My lord, the nature of corruption is, one, the making false statement and the non-disclosure of material facts, causing my lord, the same to get the published. My lord, they committed by the written candidate, my lord, respondent number 1. Sole respondent, my lord. And my lord, the paragraphs, relevant paragraphs, which corrupt factors, my lord, given specifically in my lord, election petition is at para 10.1, 10.2, 10.3, 10.4, and 10.5. And submission is at paragraph 12, 13, and 14, my lord. This is the only ground, my lord, the non-disclosure of the material facts, my lord, by the returned candidate. So therefore, my lord, at this stage, may I pray that, my lord, notice may be issued to the sole respondent, and we may be allowed to take justice service also, my lord, as well as the normal, my lord, the usual course.
Citizen elected under section 80, with section 80, capital A of the Representation of People Act 1951, presented under section 80 thereof. It is submitted by Mr. Kart that the present petition has been filed against the total respondents as written candidate who did not disclose the material fact in the form submitted before the election committee, and disclosure of material facts can be considered as a corrupt practice, and challenging to that ground only the present petition has been considering this submission made by the council, Mr. Kart. The issue notice be issued to the sole respondent to register KD as the student. So it will be listed after 3 weeks or 4 weeks.
My lord, 3 weeks, my lord.
After 3
We'll
weeks.
take justice service, my lord, as well as Jesus course during the course of the day, my lord.
Okay.
Please, after 3 weeks, my lord.
Yes, please after 3 weeks.
Deeply appreciate.
আর ওটা বিশেষ কি করতে
May please, your lordship.
किंवा गंडगोळ होतो. Who is respondent number 2, na?
Respondent number 2, madam.
Mukesh?
Manish Kumar Agarwal.
Manish Kumar.
Lordship,
So, Mr. Manish Kumar, you are appearing in person.
Lordship.
May I submit, my lord? My lord, this is height of absurdity and non-application of mine. That is how I am submitting, my lord, starting my submission, my lord. My lord, the respondent number 2 in this case lodged an FIR in Dibrugarh police station, my lord, which was registered as Dibrugarh PS case number 442 of 2018. Therein, his allegation was that he had leased out certain excavators to the accused. Subsequently, the excavators went missing. There was also issue of non-payment of money. Now, the accused in that case, he comes to this Honorable High Court, files an anticipatory bail application. This Honorable Court also grants him anticipatory bail. Now, the respondent number 2 then goes to Lotashil police station and lodges an FIR. Lotashil PS case number 326 of 19, wherein the respondent number 2, he makes an allegation that a rental agreement was submitted before this Honorable Court in time at the time of filing of the AB, my lord. That is a false document, my lord. So, accordingly, this FIR was registered. Investigation was commenced, my lord. Now, the petitioners before your lordship, my lord, the petitioner number 1 is now the additional SP of Kokrajhar. At that time, he was the Assistant Commissioner of Police, Pan Bazar. He was the second investigating officer of the case. Petitioner number 2 is the officer in charge of Lotashil police station, and petitioner number 3 is the second officer. Now, the respondent number 2 subsequently goes and files a petition under 156(3) CRPC before the learned Chief Judicial Magistrates Court, Kamrup Metro, which was transferred to SDJM 2's court, my lord. Allegation, my lord, the crux of the allegation in this 156(3) petition is that the petitioner number 1 was the Assistant Commissioner of Police. While he was an investigating officer, in his charge sheet, he wrote that the original rental agreement was collected, whereas actually a photocopy was submitted, not the original. The basic allegation against the respondent number, petitioner number 1 is that he collected in the course of his investigation the photocopy of the rental agreement, the very photocopy which was submitted before this honorable court. Regarding petitioner number 2, the allegation is that after petitioner number 1 investigated the case, my lord, he found marked variances in the signature. So he agreed with the respondent number 2's case and submitted a charge sheet against the accused that indeed there are elements of forgery. And petitioner number 2, this FIR, after the charge sheet was submitted, there was a 14-day delay in sending the charge sheet from the police station to the court. And the allegation against the petitioner number 3 is that he issued a 41-day notice to the accused instead of arresting him.
He issued
41-day notice. So allegation against petitioner number 1 is regarding collection of a photocopy of the rental agreement, because photocopy was available. Petitioner number 2, that there was a 14-day delay in submitting the charge sheet. Now, obviously, my lord, he is the officer in charge of the police station. Apart from his investigating duties, he has law and order duties, administrative duties, and your lordship is aware, after the charge sheet is received from the IO, he has to go through the charge sheet. Then he submits it to the PI office. PI office sends it to the GR branch. Then from the GR branch, it comes to the court. So there is 14-day period cannot be termed as a malicious, my lord. And regarding petitioner number 3, issuance of a 41-day notice, my lord. Now I will specifically read.
To whom? Who was the accused?
So accused in this case, Lotashil PS case.
Accused in the Lotashil.
Lotashil PS case. Against whom the allegation of forgery is made, my lord. So now I will specifically read what the respondent number 2 has written in the complaint, my lord. My lord will kindly come to page 21.
This is the complaint.
This is the complaint filed by the respondent number 2. Para 1, he mentions about the Dibrugarh PS case, my lord. Para 3 regarding registration of the case. Now from para 4, my lord, that the complainant has lodged a letter of, my lord has it, page 26, my lord. Page 26, para 4, my lord. That the complainant has lodged a letter of complaint with Lotashil police station
which is treated as first information report and registered as Lotasil PS case number 326 of 19 under sections 406, 468, 471 of the IPC on account of use of false documents in the Honorable Guwahati High Court for the purpose of obtaining anticipatory bail against Tagung Neri and Sushpal Paswan, the prime accused in Dibrugarh PS case number 442 of 2018 dated such and such. That after completion of the purported investigation, a final report considered as charge sheet has been submitted by DSP such and such ACP Panbazar, which is petitioner number 1. He has already submitted charge sheet on his complaint FIR. The investigating officer with respect to Lotasil PS case number such and such, stating that the original manufactured slash forged, now there are certain things which I don't understand, but whatever he has written, I am reading. That the original manufactured slash forged equipment rental agreement, which is the annexure 3 of the anticipatory bail application registered as AB number such and such, has been submitted by the accused persons in the Honorable High Court for the purpose of obtaining anticipatory bail, which is a blatant lie to mislead, confuse, obstruct the investigation in order to ensure and secure easy and smooth acquittal of the accused on account of lack of evidence. Thus, intentional, willful, and deliberate, defective, perfunctory investigation. It is pertinent to mention herein that on page 5, paragraph 10 of the said anticipatory application, registered as AB number such and such, it is clearly mentioned by the accused, and the accused has annexed this document as annexure 3. Here he is saying that the IO has stated in his charge sheet that original manufactured slash forged document has been submitted. Now, my lord will kindly come to page 45. Page 45.
Yes.
My lord, this is the note of the IO. So, my lord, I am reading. The fact of the charge sheet is that on 10/10/2019, the complainant Shri Manish Agarwal lodged a complaint informing that one Tagung Neri, alias Tagung Neri Talo, had filed an anticipatory bail petition vide AB number 2355 of 19 in the Honorable Guwahati High Court in connection with Dibrugarh PSK such and such under such and such sections. And with the bail application, Shri Tagung Neri had submitted a forged equipment rental agreement purporting to be executed in between him and the complainant for hiring of 4 numbers of Portland excavators. During the investigation, the complainant Shri Manish Agarwal and the witnesses had been examined in connection with the case and their statements recorded under 161 CRPC. One photostat copy of the equipment rental agreement, specimen, handwriting and signatures of Manish Agarwal, photostat copy of application by Manish Agarwal addressed to SPL DGP Law and Order and signature of Tagung Neri has been sent to DFS Assam Kahlipara for examination and furnishing of the opinion. As per the examination report, the photostat copy of application of Manish Agarwal addressed to such and specimen signature, handwriting and signature of Manish Agarwal are same, but there is no opinion in respect of the question document. That is one photostat copy of equipment rental agreement. But during investigation, it is found that the document question, that is the equipment rental agreement photocopy, has been submitted before the Honorable High Court while applying for pre-arrest bail. So, my lord, where have I written that original copy has been submitted? I have specifically stated that photocopy has been submitted. So, I do not know from where that given that version, my lord. And my lord, thereafter also, agreeing with what the respondent number 2 has said, on physical appearance, the signatures of Manish Agarwal put in the equipment agreement is far from similarity with the specimen signature of Manish Agarwal and the signature of Manish Agarwal put in the photostat copy of application addressed to SPL, DGP, Law and Order, VNAC. Under the circumstances, it is found that the accused Tagung Neri alias Tagung Neri Nalu had manufactured forged equipment rental agreement purporting to be made between himself and the complainant Manish Agarwal. So the petitioner number 1, after investigation, he has found that okay, what the respondent number 2 has said appears to be correct, and that is why I found on appearance marked differences. He has submitted charge sheet. Now he says that I have stated in my charge sheet that original agreement was submitted. Well, there is nothing in the charge sheet to show that the original agreement is submitted. In any case, my lord, the way I conduct my investigation, it is the domain of the police, my lord. The petitioner may have some grievance. For that, there are redressal forums, my lord. The petitioner could have come under 156(3) before the magistrate. Even if he was not satisfied with the charge sheet, the scope for further investigation was there, he could have come, my lord. Now, this is the allegation against petitioner number 1, my lord. Now, my lord, I am again reverting to, my lord, page 28. That the investigation of Lotasil PS case number such and such commenced only after obtaining a certified copy of the anticipatory bail application registered as AB and Sub-Inspector Lankeshwar Sharma obtained the certified copy of the Honorable Guwahati High Court. This was the first IO, my lord, Lankeshwar Sharma. And he is the first investigating officer of the case. It is clearly mentioned on annexure of the said application that it is a true certified copy duly certified by the accused advocate, not the original one. That the said equipment rental agreement which had been filed in anticipatory bail application before Honorable Guwahati High Court and marked as Annexure 3, and the said agreement would have been certified by the Honorable Guwahati High Court, official issues the said certified copy under its proper sign, seal and stamp. However, it is observed that no signature, stamp or seal of the Honorable High Court could be found in the said Annexure 3, thus proving beyond doubt that the original had not been filed before the Honorable High Court. So that is for that person who has filed. What he has filed, my lord, we have no concern over that. It is pertinent to mention that the said agreement was annexed in the anticipatory bail application, and the forensic report has submitted that no opinion could be expressed in regard to the authorship of the document in absence of original ones. That the accused had filed true certified copy of the equipment rental agreement, and the said fact was well known to the investigating officer as evident from the certified copy of the anticipatory bail application, but the dishonest and corrupt investigating officer choose to look the other way by turning a blind eye to the said fact and truth. Now, my lord, I do not know how I have turned my blind eye. I have submitted charge sheet that it is well known to the investigating officer that in absence of the original document, no opinion can be expressed by the forensic expert. Hence, the investigating officer made no effort to obtain, acquire, seize the purported equipment rental agreement. But the copy which was submitted in the court is a photocopy. We obtained a copy from the Honorable Court. No, from where we will find the original copy? We tried. We did not find. Whatever material was available on the basis of that, we submitted a charge sheet, my lord. These are issues which would anyway be decided by the trial court. Secondary evidence could also have been adduced in this regard, my lord. So, my lord, next, that the reason behind such improper, unlawful, illegal method adopted by the investigating officer can be nothing other than the fact that the investigating officer was hand in gloves with the accused and left no stone unturned to help the accused at the cost of justice. That the said fact of the investigating officer has been brought to the notice of Commissioner of Police repeatedly, also to the notice of Special DGP Law and Order, but the same has met with ignorance. The complainant states that it is horrendous to note that the investigating officer made no effort to seize the original of the manufactured and forged equipment rental document which remained with the accused, but collaborated with the accused by investigating the case without original equipment rental agreement which has been stated to be manufactured and forged one. Now it gets more interesting, my lord, from the next paragraph. That the anticipatory bail application filed by the accused identified that the accused petitioner as Tagung Neri Talo, son of late Neri Talo, as per the affidavit sworn before the Oath Commissioner, and Tagung Neri Talo, son of Sangrang Neri Talo, as per the cause title of the application of case number 2. So one late is not there, and in one Tagung Neri Talo is there, and but in the cause title it has come as Tagung Neri. It is also pertinent to mention that it is a matter of great concern to note that the prime accused in Dibrugarh PS case number such and such is in the name of Tagung Neri, whereas in the anticipatory bail application which was registered in such and such before the Honorable High Court has been preferred by one Tagung Neri Talo, son of dead man and a living person, both at the same time of filing state application. My lord, will find the frivolity of the whole case, my lord. Nowhere in the said application it is stated that Tagung Neri and Tagung Neri Talo are the same persons. It is also stated that the equipment rental agreement, which is Annexure 3 of the said anticipatory application, the name of accused appears as Tagung Neri and not Tagung Neri Talo. That under such circumstances, the investigating officer failed/ignored with malafide intention to look the impersonation committed. The name transfers from the said application as Tagung Neri Talo. Investigating officer failed miserably. That it transpires, or it is a matter of great surprise and astonishment to note as to how the investigating officer went on to charge sheet Tagung Neri alias Tagung Neri Talo when no evidence or proof is available on record to verify, identify and certify that Tagung Neri and Tagung Neri Talo are the same persons. That the investigating officer never responded to the repeated requests made by the complainant for forwarding the status report on the investigation conducted and choose to remain arrogant. No matter if there is the IO is not required to update the status report to the informant. Informant has the right to approach the court under 156(3), and from there he could have verified the status of the case. Next, that the defective, illegal, unlawful, improper, all adjectives are there. Perfunctory investigation is also evident from the fact that the investigating officer went ahead to charge sheet Tagung Neri for manufacturing the forged document and using him in the Honorable Guwahati High Court for the purpose of obtaining the bail, but left out Sushpal Paswan, the other accused mentioned in the FIR, who has signed on the said forged manufacturing equipment rental agreement as witness. The witness has not been charged sheeted. IO investigated whatever material was found, he submitted charge sheet. Now, my lord, now it comes to petitioner number 2. It is misery to note that the charge sheet is made and signed by the IO on 24/2023. But it took more than a fortnight for the officer in charge of Lotashil police station, namely Inspector Nitul Das, to forward it to the court concerned, and the said charge sheet is forwarded to the court on 6/5/23. So it took 14 days for the charge sheet to reach from the police station to court. So that is the offence committed by petitioner number 2. That on account of the delay tactics deployed by the OC of Lotashil police station with the sole aim and purpose of helping the accused by deploying delay tactics at the cost of law and justice. Now, my lord, will come to page para 19. This is regarding petitioner number 3. That Sub-Inspector Diganto Kolita of Lotashil police station, to his dishonest and corrupt conduct, upon getting hold of the accused Tagung Neri in Itanagar, Arunachal Pradesh, took and received material gifts and benefits, and instead of apprehending him, returned back by serving a notice under section 41A of CRPC upon the accused. It needs to be stated that the interstate movement was allowed for a specific purpose, to nab the culprit Nagung Neri and not to hand deliver the notice. That such improper, illegal, dishonest and corrupt conduct was brought to the notice of senior officials like Commissioner of Police, Special DGP, Law and Order, Assam Police, but they have ignored and not taken any action. And then he has gone on to reproduce section 41A, 47, 48. These are the allegations.
Basically, your case, the FIR has been lodged by him. This is the complaint. Or?
This is the complaint. After he lodged this FIR, regarding the investigation being done, this is his complaint which he lodges before the magistrate. Now, my lord will kindly come. To the impugned order, my lord.
Cognizance has been taken against
No,
him.
cognizance has not been taken, my lord. The learned trial court has page 42, my lord. Under 156(3), my lord, the court has directed registration of an FIR on the basis of this complaint. Now, my lord, this will see the way this order has been passed, my lord. Page 42. Case record is received on transfer from the court of learned CJM Kamrup Metro for disposal. Complainant is present along with his learned counsel. Heard the complainant and the learned counsel. Complainant has filed this petition under 156(3) for sending the case to the police station for investigation. Peruse the CR. On perusal, it appears that complainant has filed the affidavit. It should be complying a mandate of the apex court. It also appears that the complaint has approached even the DGP of Assam. On perusal of the CR, it also appears that the subject matter needs to be investigated. Hence, considering the grounds, let this complaint petition be sent to OC Lotashil PS, and OC Lotashil PS is directed to register the same FIR, investigate into the matter, and submit final form expeditiously. So, my lord, the first requirement for registration of an FIR or for passing an order under 156(3) is that there must be commission of a cognizable offense. My lord, from whatever has been alleged in the complaint, my lord, I fail to understand, my lord, perhaps the learned PP will enlighten this honorable court, which cognizable offense has been committed. Not correcting the original document when the original document was not available, whether that is a cognizable offense, whether, my lord, submitting a charge sheet, taking 15 days for forwarding a charge sheet from the police station to the court, knowing that, my lord, it involves a circuitous process, my lord, PI code GR1, delay of 15 days, whether it amounts to an offense, or, my lord, serving a 41A notice when the offences alleged have a maximum imprisonment of 7 years, that is complying with the mandate of Varnesh Kumar and Satyendra Rantil, my lord. Whether that amounts to an offense. When this order was passed, my lord, the learned court did not even mention which offense has been committed, which offense needs to be registered, for which offense an FIR needs to be registered. Prima facie disclosure of commission of cognizable offense is paramount requirement, my lord. That is absolutely missing. Straight away, now which offenses will be investigated into, my lord? We have done our duty. Any issue grievance which he has, he can take it up before the court. That avenue is open for him, my lord. But to prosecute me for this, in that manner, any person, any informant who has any grievance against any investigating officer will come and lodge an FIR. And that too, my lord, this whatever the respondent number 2 has alleged, these are all in discharge of official duty. Now, when I'm providing the judgment, Honorable Supreme Court has made it very clear that even at the stage of passing an order under 156(3) CRPC, in respect of public servants, for offences committed in the discharge of their official duty, sanction is necessary. There is nothing on record to show that he has obtained sanction, my lord. In this case, my lord, this is a case of, my lord, vexatious litigation aside, my lord. I am sure the respondent number 2 may have his grievances, my lord. But for that, my lord, the investigating officer, OC, and the second officer cannot be prosecuted. And the way in which this order is passed, without mentioning what offense has been committed, which cognizable offense is made out, and without insisting on sanction, my lord, which is required, my lord. I am providing the judgment, my lord. First, my lord, Priyanka Srivastav, my lord. They have submitted an affidavit in terms of Priyanka Srivastav that they have approached the police and the senior official, my lord. But Priyanka Srivastav goes beyond that, my lord. Apart from submission of affidavit, my lord. Para 22, my lord. Para 27. My lord has it, para 27, page 305.
Yes.
Regard being had to the aforesaid enunciation of law, it needs to be reiterated that the learned magistrate has to remain vigilant with regard to the allegations made and the nature of allegations, and not to issue directions without proper application of mind. He has also to bear in mind that sending the matter would be conducive to justice, and then he may pass the requisite order. The present is a case where the accused persons are serving in high positions in the bank. We are absolutely conscious that the position does not matter, for nobody is above the law. But the learned magistrate should take note of the allegations in entirety, the date of the incident, and whether any cognizable offense is remotely made out, my lord. So, my lord, before passing an order 156(3) CRPC, the magistrate has to apply his mind to see at least if there is even a prima facie allegation of commission of a cognizable offense, my lord. That, my lord, is clearly missing from the complaint as well as from the order, my lord. Para 30, my lord. In our considered opinion, stage has come in this country where 156 CRPC applications are to be supported by an affidavit duly sworn by the application, which seeks the invocation of the jurisdiction of the magistrate. This is regarding, my lord, whether he has approached the earlier forum. Next, my lord. That apart, in an appropriate case, the learned magistrate would be well advised to verify the truth and also can verify the veracity of the allegations, my lord. So, my lord, that is clearly missing from this order, my lord. Now, my lord, will kindly come to the other judgment, my lord. Anil Kumar versus M.K. Ayappa, my lord. Para, my lord, we'll have para 17. Page 713, my lord, para 17. The question is framed here. We may now examine whether in the aforementioned legal situation, the requirement of sanction is a precondition for ordering investigation under section 156(3) CRPC, even at a pre-cognizance stage. Now, my lord, my lord will find the answer at para 21, same page, my lord, last part. The learned senior counsel appearing for the appellants raised the contention that the requirement of sanction is only procedural in nature and hence directory, or else section 19(3), my lord, the parameter provision in the PCF, would be rendered odious. We find it difficult to accept the contention. Subsection 3 of section 19 has an object to achieve, which applies in circumstances where a special judge has already rendered a finding, sentence, or order. In such an event, it shall not be reversed or altered by a court in appeal, confirmation, or revision on the ground of absence of sanction. Now, that does not mean that the requirement to obtain sanction is not a mandatory requirement. Once it is noticed that there was no previous sanction, as already indicated in various judgments referred to herein above, the magistrate cannot order investigation against a public servant while invoking powers under section 156(3) CRPC. So, my lord, this is the legal position of law. Subsequently, this issue has been referred to a larger bench, not yet decided. As of now, this remains the law, my lord. That even at 156(3) stage, my lord, if there is allegation regarding commission of a cognizable offense, which anyway is not here, magistrate needs sanction, my lord, before this order under 156(3) can be passed. So, my lord, that is why we have come before this honorable court challenging this order, my lord. My lord, yes, my lord, if there would have been some grave serious allegation against the petitioner, I would have not support my friend, my lord. But in this case, my lord, while he submitted, my lord, everything rightly pointed out, my lord. Yes, your lordship, I would just like to point out, your lordship may kindly come to page 6, my lord. Page 6, my lord. 1, 2, 3, 4,
Page 6 of the petition.
Yes, 6 of the petition, my lord. 6th line, my lord. The respondent number 2, my lord. What is his allegation? Because only allegation is that while submitting a bail petition before this honorable court, he submitted a false document. That is the allegation. And thereafter, my lord, further, my lord, other things, my lord, continued, and later on he lodged an FIR. And in that FIR, police filed, my lord, already investigation completed, filed charge sheet against the petitioner that by way of submitting a false document on the basis of the allegation of the, my lord, the present respondent number 2, thereafter charge sheet submitted in this case. And I would like to just point out, the respondent number 2 has alleged that the earlier investigating officer had obtained a certified copy of the bail application, and therein it was clearly stated that the agreement was a true certified copy and not the original one. And my lord, what happened if I filed a, my lord, bail petition or any petition before this honorable high court? Then all the annexers, my lord, at the time of annexing along with the petition, then advocate had to make it certified to be true copy, my lord. Only by, my lord, comparing with the, my lord, that copy provided by the, my lord, petitioner. So on the basis of that copy, my lord, in that case, my lord, the advocate who has filed the bail petition, my lord, against the, my lord, him also, my lord, he would also have been a party, my lord, because, my lord, who has forged the document? The accused person, my lord, and he is on the basis, and in the bail petition, my lord, in the bail petition, my lord, although, my lord, there is a fight between two, my lord, I am pointing out because the allegation is some of the, my lord, respected, some of the, my lord, police officers also, my lord. That's why I am pointing out. And because, my lord, if there is some grave allegation against specific allegation against the police personnel, then also I would have not support the petitioner, my lord. But here only because, my lord, the petitioner has filed a, my lord, filed an annexer, false document accused, my lord, along with a, my lord, bail petition. That can be, whether that can be a ground to continue with the, my lord, this type. Otherwise, my lord, every person will come and file, make all these allegations and file complaint petition. So the learned should have, my lord, verified all of these aspects, at least gone through it and seen what offense was made upon. If any conspicuous material was available, my lord, in that case, my lord, the learned court would have been perhaps justified. Even then, sanction would have been required. But apart, even if the sanction issue is set aside, some conspicuous material needed to be there, my lord. Nothing is there, my lord. On these grounds, my lord, if FIRs are allowed to be registered, my lord, no police officer will be able to do his duty, my lord. These are the cases for which these protections are provided, my lord. Whatever grievance he had regarding the investigation of the case, he had, the liberty was always with him to approach the court under 156(3) in the Tatashil PS case, not to come after me, my lord, for investigating the case, my lord.
Lordships, may I be allowed to put the picture very clear?
Yes, yes, you can.
Lordship, for a brief moment, I was not online, so I could not take up what the learned counsel has submitted. But the case as put up by the learned counsel is not the true picture of the case. Here, the case is that a person approaches the Honorable High Court with a forged document to obtain a bail. I file an FIR. That FIR is in perfunctory investigation is carried out deliberately by the IO. It is well-known fact that in the petition filed, a certified copy is put up by the petitioner. So when the IO was required to investigate the facts of the matter, he was required to obtain the original of the forged document, which he never did. He submitted an charge sheet in the matter stating that the original is in Guwahati High Court. So what restricted the IO to get it from the High Court? Nobody. But he never approached. He never put up a 91 CRPC notice with anybody to produce the original documents. The FIR was deliberately kept waiting for 4 years. It was filed in 19. They kept on harping on it for till 23. And the best part of it, my lord, a matter has just come up in the Honorable Court of Honorable Justice Pathak. It was just heard just now. Criminal Petition 558 of 24, where the accused has said that he was never issued a summons or notice in the case. Whereas the charge sheet says that the accused has not been arrested because of 41A notice. What else can we find a connivance with the accused? Is filing false document in the court is not a grave offense? Is conniving with the accused is not a grave offense? 197 CRPC comes into play when you have got to take cognizance of the matter, not before that. And the officer in charge, Latashil, was duty bound to obey the orders of the Honorable SDGM too. He had no other way other than obtaining this. But it is a case of police helping police. You kept on waiting for 4 years and then you file a charge sheet saying that we don't have the original. What sort of a charge sheet it is? You are just helping the accused out. Now your dear accused has put a finger on you that you never issued a notice or summons. I will request the accused to be made a party in the case so that the truth comes out. It is a clear case where you will see that the investigations are deliberately being laid in a sense where the accused lets out and they are allowed to go free when they do forgery in the court of law. It was deliberate, perfunctory investigation carried out in connivance with the accused. And now the accused has come up even on the charge sheet. The charge sheet says the accused has not been arrested because of 41A compliance. And the accused is harping that I was never issued a notice. Is that not a offense, my lord? Is a policeman guilty of any offense is not to be treated as any other criminal? Why not a 156(3) petition will lie? You go face the IO. If I have made a false affidavit, I will face the court under 182 and 211. Why do you have to come here? You being a part of the force, your own police officer will investigate it. Why is the fear of it? Why have you come with a quashing petition? It doesn't lie at all. You have connived with the accused. You kept it for 4 years. What is the observation? What is the value of the observation made by an IO without a forensic report? You never got hold of the original false documents. Is fraud played out in the court is not a grave offense, my lord? Is the police officer greater than the law? Go face the IO. If it is a false FIR, I will be facing the court under 211 and 182. How can it be allowed? It is not a matter of absurdity. It's a matter of great shame that a police officer is conniving with the accused, and such person should be dealt with ruthlessly. No mercy should be shown on them. When a 156 petition is allowed, there is no way other than the OC to register an FIR and investigate the matter. Who is he to sit on it for so many days? He has got no power to disobey the court's order. Whether the complaint is a genuine one or a wrong one will come out in the investigation. Now the accused is putting a finger on you that you never issued a summons. How did you get all these investigations done? Let the accused be made a party in this case. It is real mockery of law that is being going on. A OC is disobeying the power orders of a SDGM2, Kamrup Metro. How can he? Whether the orders are right or wrong, whether the FIR is right or wrong, that will be as a part of the culmination of investigation. So, you kept 4 years to investigate a forgery in Guwahati High Court, and then you come up with a charge sheet and the original is not there. Then the accused says that I will never issue a summons by notice. What else material is required against you? You have laid down your oath of duty. You are not fit to be a police officer at all. How can you come up against that? Such petitions should be dealt with, my lord, ruthlessly. How can he come up? Let the investigation go. You are a police officer. You have not been arrested. It's a case of police helping a police. Why are you so fearful? I am ready to face the law if I have made a false complaint. It's just a mockery of law. You kept on 4 years investigating a case of forgery in High Court. Now you say that you are innocent. How can you be? You have connived with the accused. Now the accused is after you. He says that you have never issued a notice or a summons, and that is on oath. You just go to the criminal petition 558, just gone in the court of Honorable Justice Manasanjan Pathak. It cannot be so. We put such a high faith on the police officers.
So you want
My lord, just a simple rebuttal, my lord. FIR lodged by him has already been charge sheeted. It's not a case the police has submitted.
It's not a charge sheet. It's a way making him out for acquittal. Where is the material? What value you hold in an investigation without a forensic investigation? Is your opinion of any value? No. Even the forensic doesn't have a value of 100%. It's 85-15. And now the accusation has come up against you saying that you never issued a notice or a summons, and that is an oath. I say the investigation will bring up skeletons from the cupboard. That what sort of a investigation has been done by you and whether you are fit to be a police officer or not. Why do you fear of being facing the investigation? I don't fear to be charge sheeted under 182 or 211 if I have filed a false FIR.
Okay.
And you must remember your submissions made in criminal petition 214 of 2022.
Nothing much to add, my lord. The only thing is that the complaint, my lord, it is not what I have submitted in my petition. I have read out his complaint, my lord. My
complaint is very simple. Let it be investigated. If I have made a false FIR, I will face the law. As good as that. It's a case of police helping police. The orders of SDGM 2 has not been honored. The OC Latasil is under contempt. Who is OC Latasil to disobey the orders of the court? There are certain provisions. 197 comes into play.
You made this submission, okay.
So, my lord,
thank you, my lord.
Investigation has been done, charge sheet has been submitted. Any grievance which he has, if he says that there is an original document required, these are issues which can be, he could have filed a 156(3) petition before the court at the time of submission of charge sheet. Before framing of charge, at any stage, he could have come under 156(3) saying that this investigation was done perfunctorily. Does doing even if we assume whatever he's saying is correct, does doing a perfunctory investigation amount to a criminal offense, my lord? The Real Lordship will examine that issue whether it amounts to a criminal offense, my lord. If there is a document available, this 91 application can also be filed by the prosecution during trial. So there is not a single issue which does not have a remedy available, my lord. Allegation against all three of us, my lord. For 2 and 3, my lord, is absolutely frivolous. Against 1 is that he did a perfunctory investigation. Assuming it to be correct, does not amount to any cognizable offense. Regarding 2, that is, my lord, absurd and preposterous, my lord. It takes 14. It will take time, my lord. My lord has also been served in those courts, my lord. It requires some time, my lord, for a charge sheet to reach the court, my lord. It has to go through a circuit, my lord. And issuance of 41A notice, my lord. That is a mandate of law, my lord. If I follow the mandate of law, my lord, where have I committed a cognizable offense? If I have not committed a cognizable offense, then, my lord, 156, the first requirement is that there has to be cognizable offense. That is not there. And sanction, what he has submitted is not the law. I've placed the correct law, my lord. Even at 156(3) stage also sanction is required. Let him produce sanction, my lord. Let the matter be remanded back, my lord. That is my submission, my lord. Let the matter be remanded back to the learned SDGM with a direction that the learned SDGM will decide whether any cognizable offense has been made out in this case. If any cognizable offense has been made out, that has to be specified. And secondly, my lord, he will produce the sanction before the magistrate. If these two things are satisfied, my lord, let the FIR be registered. I will face the consequences. But, my lord, due procedure has to be followed. That is the mandate of Article 21, my lord. I cannot be.
The FIR has already been registered or not?
No, my lord. They have already sent the FIR. By the time we have already approached this honorable court, my lord. As far as mine, but we do not know, but the state will know, my lord. After getting to know of this order, we have come before this honorable court, my lord. So we are saying, my lord, let this order be set aside, let it be remanded back, let the magistrate decide this matter afresh, seeing whether cognizable offences are made out or not, and let him produce sanction.
My lord, I would like to make clear one thing, my lord. My lord, the state is not supporting any of the police personnel in doing any illegal act, my lord. But here I am just in this case only pointing out, because only allegation is that some accused person has, my lord, while filing a bail application, he annexed a document. That document is forged. In that case, my lord, what IO can do, my lord? If somebody is any accused persons come before this honorable court along with the bail petition, he may file any of the documents, and for that, my lord, how a police person can be responsible, my lord? So because of that, I am just pointing out. Otherwise, I am not supporting any of the, my lord, illegal act of any of the police personnel, my lord. Only because regarding in this case, because prima facie it seems that considering the allegation, I am just pointing out to your lordship.
Now, remanding back the case, that means the officer has already most probably sent the case record before the IO.
My lord.
Investigation,
Investigation, my lord. So if my lord is pleased to remand the matter back, my lord, they will submit a copy, my lord. State will send it back, my lord. Let the court decide it afresh, my lord. And on these two conditions.
And regarding the original document, my lord, in many, my lord, land matters also, land cases also, your lordship very much aware those my lord, original documents never reached to the hand of the police.
The question is that 91 can be also applicable at the stage of trial.
Trial also, my lord.
91 can be served. That if you have the document with you,
Yes.
or the other side.
And
is
now also
searched,
there is scope
it
for my lord further
Further
investigation.
investigation is there.
1738, my lord. Now also if somebody my lord submit the original my lord document before the police, then also
Yes,
police can file
173
additional.
it can be. Can be.
Problem is not somebody has given a full photocopy. That is not, we tried, we could not find a photocopy, because if the allegation is that photocopy has been submitted, but where will we find the original, my lord? For these kind of matters,
And
my
he,
lord,
my
whether
lord,
prosecutors-
understandably because certified to be true copy, and he, my lord, misunderstood that that is a, my lord, original certified copy, my lord. That is, in fact, my lord, any document, if I file a petition, my lord, in fact, I sign it as certified to be true copy after going through the contents of the, whether this is original or not, sometimes we also not go into that, my lord. We are next.
Okay, I'll pass you on.
my lord.
No,
Deeply obliged, my lord.
Mr. Bhattakur, yes, I want to ask you, he appeared in person through BC.
Yes.
So his, what to do? His appearance can be.
Otherwise, my lord, as per High Court
rules, my lord, he has neither filed any wakalatnama. Notice was also not issued to him, my lord. Lordship may record his presence, my lord.
As per your,
This also, since your lordship has already heard him. Deeply obliged, my lord.
My lord, I will not take so much of time. I will not trouble your lordship. I will conclude. Just I am giving a two, my lord, judgments. Oh, that is all, my lord. There is one, my lord, which I want to rely, my lord, was there is a 2013 9 SEC, my lord. My lord, here, what has happened, my lord, that's, that 2000, this in the same cases, my lord, it has been, the charge sheet has been quashed, relying on the judgment of, my lord, what I have 2013 3 SSC, my lord, 330 Rajiv Thapar's case, my lord. Where what has happened in this case, there is an, my lord, FIR has been lost by a lady against the petitioner before lordship did the case. Then he has said that this petitioner has come to me and have a phone, and he has come and give him a Coca-Cola where there's a poisonous, and she has been taken to the AIMS. Thereafter, he has made a statement also thereafter that he has, by taking unconsciousness, he has raped on me also. So that her statement has been recorded, charge has been framed, and defense, during that, he challenges that the High Court also not, the charge has been framed. Then Lord, he has come against that. Now, when he's gone, this matter has been discussed regarding defense, what is on the support of his defense, what is submitted, that has been considered. Paragraph 22 onwards. I will not go through entirely. I will just 22 onwards. It has been relying on the decision of my lord 2013 3, my lord. Then, my lord, another one, my lord. The Madhav Rao Scindia's case, my lord, reported in 1988, 1 Supreme Court, 692, my lord. Paragraph 7, my lord. The legal, my lord, position, what it has been stated regarding discharge, my lord. that the legal positions, just one line I just referred in, position as well is well settled that when a prosecution of the initial stage is asked to be quashed, my lord. The test here also, the prosecution is at that initial stage, my lord. The test to be applied by the court is that whether the uncontroverted allegations as made prima facie establish the offense. That is number one, my lord. It is also for the court to take into the consideration any special features which appear to be a particular case to be considered whether it is an expedient and in the interest of justice to permit the prosecution to continue. This is so on the basis of which the court cannot be utilized for any oblique purpose and where, in the opinion of the court, chances of an ultimate conviction is bleak and therefore no useful purpose is likely to be served by allowing a criminal prosecution to continue. The court may, while taking into the consideration of special fact of the case, also quash the process, even though it may be at the preliminary stage. So this clearly established that even in the preliminary stage, because the case is the preliminary stage. Now, number one, what that the statement which has been recorded under 161 does not, my lord, anyway, not support the case. That is number one. Number two, the witnesses where they have cited, my lord, they said in the defense, I said they with the documents, they said to the police, we never, my lord, depose anything as what it been stated. It is what we have been, somebody has said that it is because of so and so, so and so. All are hearsay. And thirdly, my lord, there cannot be two proceedings of the same offense. In one proceeding, I am the accused, and one proceeding, I am the witness. Can it go like that, my lord? It cannot be, my lord. So my respectful submission is this: in view of the law laid down, my lord, and the material available on the records, it's a case, my lord, where your lordship can interfere under section 482, my lord, for quashing, even at this initial stage. That is my humble submission, subject to what my learned friend said.
Yes, my lord. Now, my lord, I would like to point out to your lordship, my lord, whether, my lord, regarding the present case, my lord, whether prima facie, my lord, this is a case, my lord, whether by your lordship can interfere by the, my lord, in the by of this 482 application, whether there is a prima facie case and whether continuation of the present proceeding is a abuse of the process of the court. And from the prima facie, from the FIR and the other materials on record, my lord, I'd like to first, my lord, because, my lord, it has been submitted, my lord, continuously, that this is, my lord, regarding that this is a second FIR, multiple FIR. Regarding the earlier case, which was, my lord, FIR was quashed, I would like to, my lord, directly take to your lordship to page 58, my lord. I would like to point out to your lordship why that FIR was quashed, my lord. That is the, my lord, FIR lodged by Rohit Das, my lord. Third FIR, my lord. Not third FIR, my lord. Your lordship may kindly come to relevant portion, page 59. Page 59, last paragraph.
Yes.
Apparently, the subsequent FIR dated 31/7/2016 was not a cross FIR. Since the Gorsuch PS case number 397/2016, the present case 397/2016 was already registered, there could not be any second FIR for the same incident. At best, police could have considered a subsequent FIR as a statement under 161 CRPC, and as such, registering the second case for the same incident on the basis of the FIR lodged on 13/7/2016 prima facie appears to be illegal. That apart, the respondent number 2, informant himself, stated on affidavit that he made such statement in the FIR out of provocation and at the spur of the moment. Be that as it may, since there was already an FIR and the case registered on the basis of the said FIR was pending for the same incident, there could not be any more FIR, though the same could be treated as the statement under section 161 CRPC, and as such I find merit in the submission made by so and so. In view of the above, this court is of considered opinion, your lordship, this is vital, that this is a fit case where the FIR dated 31/7/2016 and the Gorsuk PS case number 401/2016 deserve to be quashed for the ends of justice. Accordingly, the FIR dated 31/7/2016 and the Gorsuk PS case number 401/2016 under section 120B so and so, GR case number so and so hereby quashed. However, the said FIR dated 31/7/2016, the present FIR, my lord, can be kept with the previous case as subsequent statement as indicated above. Yes, my lord. This is not the present. So first FIR is the present FIR dated 27/7/2016. So why that FIR, my lord, 416/2016 was quashed? That, my lord, considering in view of the Supreme Court decision, that's subsequent FIR on the same incident, that subsequent by FIR may be treated as 161 statement under CSPC, and for which, my lord, subsequent FIR was quashed. So that is the ground for quashing that FIR, my lord. So, my lord, now the present FIR is the first FIR. So there is, my lord, continuation of the present FIR that by honorable, my lord, by this order, the honorable court has not was the present case, my lord, because this is the first FIR. So and there are some specific allegation in the present FIR. So honorable court has rightly quashed the second FIR 401/2016. And now, my lord, regarding the my lord, contents of the first FIR, your lordship, because, my lord, the first ground that, my lord, the second ground that, my lord, multiple FIR, my lord, that I clearly pointed out, your lordship, that in view of that ground, that FIR was already quashed by this honorable court. And regarding the, my lord, whether the prima facie, my lord, any cognizable offence made out from the contents of the FIR and the materials available on record, my lord. So, my lord, your lordship, from this FIR, your lordship, I would like to point out, my lord, this FIR is lodged by, my lord, the Director, Fire and Emergency Service Station, my lord.
This present.
No,
Yes. Station officer.
Station officer.
Station officer, my lord. Fire and Emergency Service Station, my lord. With due respect, I would like to inform you that on Iman so and so, my lord, really, I will just like to only point out relevant portion, my lord. Be it noted that, my lord, on 19/6/2016, second paragraph, my lord, at about 11:50, a fire broke out at the godown of the same factory, and after 15 to 20 minutes of the incident, another fire broke out at the same place, and it took 48 hours to put out the fire. On investigation of the incident, written statement of the two workers of the factory was received, which was enclosed here, Amal Saloy and Borun Pandey. So specifically on the basis of their statement, this FIR is lodged. All the incidents, and moreover, my lord, this is also vital, all the fire incident in the above mentioned factory took place at night about 11:50 p.m. on 19/6/2016 first, on Iman dated 26/2/41, and again on 24th. There are on 3 occasions, my lord, that fire broke out in that factory. So now, my lord, from the contents of the FIR prima facie, it seems that a cognizable offence has been committed by some person, my lord, unknown, because here specifically no name mentioned, my lord, who has, my lord, put this FIR, put this, my lord, fire in the factory, my lord. So there is no specific name mentioned. Anyway, my lord, prima facie, it seems that a cognizable offence has been committed by someone, my lord. From the contents of the FIR, and specifically 3 dates mentioned, and in the same manner, my lord, in the same place, my lord, that type of fire earlier also broke out in the factory. Now, my lord, there are many, my lord, agreements, and my lord, there are, my lord, settlements between the, my lord, here I would also like to point out one thing, my lord. In one hand, my lord, there is a factory, Sunrise Biscuit Factory, and there are, my lord, unions, their employees. And here FIR is, my lord, who has lost the FIR, my lord, fire service station, my lord, who are the personnels, my lord, who by taking out their life at risk, my lord, go to the places, my lord, wherever they got information regarding if any fire broke out, for drowsing that fire. So by taking their life at risk, they are the persons who immediately went to the places for drowsing the fire, my lord. And the present petitioners, my lord, are the employees of the factory, and the what they have done, they made all these agreements between them, between the my lord factory and the my lord their employees. And now by making agreement between them, they are trying to settling the matter. What is the matter, my lord? Somebody is trying to, yes, your property, your factory is your Sunrise Biscuit, my lord, is your property. You can make agreement with the parties because ultimately you will suffer the loss. You can make any kind, because your factory is going to, my lord, fired by somebody. So ultimately you are at loss. Definitely you can make agreement between your employee and you can make lot of settlements. But where, my lord, you have, my lord, this type of incident occurred, my lord, you immediately informed the, my lord, fire and service station, and they found that some suspicious, my lord, incident was going on, not only in, my lord, at one point of time, but 3-4 point of time. You immediately call them, and thereafter they immediately rush to the place, and thereafter they seen that in that place there are lots of, my lord, gallons of, my lord, there are some, my lord, some of the, my lord, products where they are also, they suspect, because same type of incident earlier also occurred. So by taking their life at risk, my lord, they went to the places and they drowsed the fire. So that is a, my lord, prima facie regarding the FIR is lost, considering that because of that incident. So, my lord, now if suppose, my lord, some in nearby Sunrise factory there are, my lord, lots of residential houses, many houses, then if suppose, my lord, fire broke out and later on everything was damaged, then who will, my lord, compensate? Can the, my lord, agreement between the parties will solve the entire offense under section 436? So these are my submissions, my lord, considering, and because there are material, because on the basis of the my lord, statement of the, my lord, those, not only the statement of the, my lord, employees of the as mentioned in the FIR, but from the incident, not only, my lord, one time, my lord, 3 occasions on 3 dates, my lord, in the same place, in the same factory, that incident occurred. So this is not only a case of suspension, my lord, not only, my lord, this is a my lord, a case wherein, my lord, it is prima facie, it seems that yes, something happened there and somebody tries to, my lord, put fire in that factory, my lord, to cause damage. So, my lord, prima facie there is nothing to enter because charge not yet framed. So considering all these things, well, at this stage my prayer before, like, otherwise, my lord, informant also appeared, my lord. He is appearing on behalf of the, my lord, fire service, my lord. He will submit it. My lord, this is not a fit case at this stage to interfere under section 482 by this honorable court, my lord.
My lord, here I am appearing for the informant, my lord. And lordship has already has done for the, my lord, my affidavit, my lord. My lord, we have received the information that there is an incident of fire in the factory, my lord. So we rushed to the place, my lord. And on inquiry, my lord, we came to know that on earlier occasions also the same incident took place, my lord. So on the basis of the statements of 2 workers, my lord, this FIR was lodged, my lord. And I am only the informant, my lord. The investigation was carried out by the investigating officer. So, my lord, regarding this change of statement of the 2 witnesses, my lord, that, my lord, I have no knowledge, my lord. And moreover, my lord, they have not made the investigating officer also party, my lord. So I can only say that, my lord, on the basis of the 2 statement of the 2 workers, my lord, that this FIR was lodged, my lord. So the record has come. Lordship will definitely go through the record and see, my lord, whether the statements were actually changed or not, my lord.
Well, I'll give a short reply to my learned additional publication what is stated. Referring to the judgment of the Honorable Court, what it says is just highlighted that portion that there cannot be a multiple FIRs on one issue, my lord, and rest can be taken as an 161 statement, my lord. Now, what he says is that it can be. If the judgment says, so how the second FIR can be there? There cannot be parallel proceeding. So that has to be taken as a 161 statement. If you go by this, their own statement, my lord, that is number 1, my lord. Number 2 is what? The question is what? But we are not here appearing before a civil court. where preponderance of probability is to be there, my lord. Here it is beyond, it's a criminal jurisprudence, my lords. We have to go by beyond all reasonable doubt, and you have to be very specific, my lord. Now, what is the case? The facts, what is narrated so and so, doesn't appear. We are challenging the entire search sheet. The law is this: the parallel proceeding cannot go. In one cases, I am the witness, and one cases I am I'm the accused. Now, both the cases, I cannot be an accused and cannot be a witness, my lord, of the same offense, my lord. Can it be, my lord? In one trial, the same offense, I am a witness, I am an accused, my lord. How it can be, my lord? That is improbable, my lord. Is it probable, my lord? One cases I am an accused, one cases I am a witness to the same offense. That is an improbable. And it is an improbable, my lord. If your lordship kindly see that the Bhojanlal case, improbability is there, my lord, where the case is absolutely improbability, the court can quash this. Second is what this thing, these two witnesses, the complainant says that on the basis of so and so, and the two from where the entire case is set in motion, they say that no, we are so and so have done. And being in management, one thing is, will I put my factory to on fire, my lord, making a loss? Definitely not, my lord. So that is my humble submission. Your lordship will find that is a two-part your lordship has to see. Number one, if you go by the judgment of this honorable court, the second affair has to be treated as an 161 statement. That is number one. Number two, the parallel proceeding of the same offense cannot go where I am a witness and so and so. That is absolutely improbable. And thirdly, my lord, the reasonment of the witnesses, my lord, 161 statement. The question of, my lord, further proceeding with this case does not arise at all, my lord. That is my submission, my lord.
Well, I would just like to only point out 3 dates, my lord. The present case, my lord, present case 397 of 2016, my lord, laws on 27/7/2016.
Present case, sir?
Laws on, my lord, FIR laws on 27/7/2016, wherein the present petitioner is also an accused, my lord.
And
and second case, my lord, 398
that is mine.
Of 2016, laws by the present petitioner on 28/7/2016. And my lord, other which the FIR was already quashed, that was laws on 31/7/2016. So the present FIR is the first in point of time, my lord.
If it is so and so, then 161, I am be a witness. How can I am accused there? I'll be a witness at the best. It's your submission.
My lord, otherwise from the contents of the present FIR, it seems that to get rid of the, my lord, because already one FIR is lost by the, my lord, thereafter, because incident occurred on 24/7/2016. So if you are a manager of that factory, why you have not immediately secondly lost the FIR, my lord? Only because when the present FIR is lost on 27/7/2016. So thereafter, immediately the present petitioner, my lord, on 28/7 lost the, my lord, FIR on 398/2016.
Only, my lord, just adding, my lord. My FIR is what? Not only, my lord, 434. It is for mishandling me also. My FIR was that I have been kept confined in the room, my lord, by the workers, my lord. And I have been assaulted also. That is why I have been assaulted also. I have been kept confined, my lord, by the workers. That is the, my lord, the contention of the FIR, my lord. I have been kept there. I have been confined. I have put to force so and so. If you do these things, if you do not do, I'll do these things. Can he answer to that, my lord? Prosecution, no. We have. That is why 28, my lord. That has been clearly stated in my FIR, my lord. And offense also been there regarding assault. Apart from that only, the assault and others has been added. I am obliged, my lord.
I think. Call, right?
Everything.
What I think. These are what?
IA has been filed, my lord. That was not come. That's why it was on for, my lord. In this case, your lordship, this petitioner, my lord, he was a second party in a DB case, my lord, where there was an order for payment of compensation of a monthly maintenance of rupees 6,000, my lord. That your lordship will find at operating page that page.
What are those I?
IA for stay, my lord. Because there was some development during the pendency of the petition, my lord. That's why we have filed the IA.
Where is the at the page number?
No, in the main case, my lord, this criminal petition number 860, my lord. That page 20, my lord. Your lordship will find. There was direction. Number 8, my lord, column number 8, my lord, paragraph 8, Roman 4, respondent is directed to pay monthly maintenance of rupees 6,000 per month to the aggrieved person. That is page 20, my lord. He preferred an appeal before the statutory appeal before the district judge, my lord, session judge, my lord, and the learned session judge, my lord, who had ordered it that your lordship will find next page, my lord, page 23, my lord. It was reduced to 5,000 per month. The husband is there, quote, it is session number 2, my lord. And now what has happened? Thereafter, he started paying on a regular basis, my lord. But subsequently, in the month of 2023, there was a default. As a result of default, my lord, non-null warrant of arrest has been issued against him, my lord. And finally, my lord, he was taken into custody, my lord. And in fact, there was an application filed by the aggrieved person, my lord, for taking him into custody. That was in way back in 2023. 4/4/2023, it was passed, my lord. That your lordship will find that is at page 38, my lord. Page 38, my lord. Annexure G, my lord. That is the aggrieved person's Noyan Moni Sakya, my lord. There she states that due to respect the petitioner, begs to state that the case is posted for execution. On the last occasion, due to non-payment, your honor was pleased to issue so and so, so and so. Today, he has paid rupees 7,000. The aggrieved party will not accept. The response is that please pay 50% full amount. The response is very much irregular as he is prepared. Hence, your honor may kindly please to take him custody on the state of warrant. And this on the basis of this petition, my lord, he was taken into custody. And he was sentenced for 1 month imprisonment. That is under section 125(3), my lord. Now, against that order, my lord, that he has preferred in a division petition, my lord, before the honorable court, that page 39, your lordship may kindly see, that petition, criminal petition is still pending, where this honorable court has directed that page 41, 40, to pay that page 40, your lordship will find last page, my lord. Upon hearing the counsel is provided intending to petitions and deposit 60,000, how to clear the 50% outstanding dues, and to pay the remaining 60% within the period of 1 month, so and so. On the event, so and so, you will release forthwith before the expiry of custody period. But since he could not pay the amount, ultimately, after expiry of 1 month, he was released, my lord. Then we file an application before the learned trial court, my lord, before execution court, that your lordship may kindly come, page 50, my lord. There we have, basically our contention was there, my lord, that your lordship will come to page 51, my lord. That page 51, page 50, the respondent begs that the amount of 5,000 was due since 2020 after expiry of 2 months as directed by the honorable court in DB case. However, the aggrieved person never approached the court for recovery of the amount. Only on 4/5/2003, an application was filed by petition number 770 of 23 before the Chief Judicial Magistrate for recovery amount. Now, section 6(5) of the Protection of Domestic Violence says that the application of section 12 will treat as an orders passed there will be enforced in the manner provided under section 125. But however, section proviso to section 125(3) says that no warrant shall be issued for recovery of an amount under this section unless an application is made to the court to levy such amount within a period of 1 year from the date which is due. Thereby meaning the aggrieved person has to initiate the proceedings for 1 year from the date of passing of the order, that is 31/12. So our basically contention is that, Your Honor, that there's a limitation of 1 year. 1 year from the date of due, he has to file an application. Then only court can exercise the power under section 120, levy of fine, imposing a fine. So non-bona they can put me into custody for 1 month. But since already it was all beyond limitation, so that power cannot be exercised. Now what has happened, this court, my lord, that Your Lordship may calendar, that is order dated 29/5/2024 is the impugned order, my lord. There Your Lordship will find what the court has done, my lord. Court, the learned court below, my lord, has discussed page 53, my lord. There is impugned order 29/5/2024. Now, this is a long order, my lord. I'm coming to the finding part, my lord. That page 656 is the finding, my lord. The board has perused the case record, my lord. Upon such hearing and perusal of the instant case, it transpires the respondent Nishan Sugar till they failed to clear the outstanding dues due towards the maintenance. Judgment of Muhammad Usman versus State of UP reiterated well settled that applying the aforesaid principles of law, the proviso of subsection 3 of section 125 would have to be held to be confined to the section precedes therein. Limitation of 1 year provided in terms thereof would be read with so and so. That is the aforesaid limitation of 1 year under proviso cannot be held to be travel beyond the stretch to such extent to being within the ambit of powers relating to enforcement and order maintenance under 128. It therefore deduced from the scope of 128 being different, and the first proviso on getting an interdict only issuance of warrant for recovery. The said period of limitation of 1 year cannot be held to create a fetter on the right so and so. Proceeding of the enforcement order under 1 year therefore cannot be assailed on the ground on the being limitation. Therefore, coming into view. Now what has happened? He has said that the learned magistrate has of the view, my lord, the 125(3) is applicable, so limitations, but he is exercising the power under section 128. You will also make at see. 128 is because he says that proceeding enforcement under 128 therefore cannot be assigned on the, because we are not assigning on that. We have said you cannot put me into jail for 1 month on regular basis. What he has been doing, man? Because there is a limitation bar is there, and since in 2000 it was a case of 2020 already 2 years has lapsed by the time they filed the application for execution of the order. So my submission is that since 125(3) there is a bar, so they have to go directly to 128. If your lordship takes up 128, my lord, of the CRPC, my lord, it's says that a clear order, my lord, a copy of the order of maintenance or interim maintenance expenses proceeding of a case shall be given without payment to a person whose favor it is made, to the guardian if any, and to a person whom allowance of maintenance or allowance of interim maintenance expenses of the proceeding is to be paid, and such order may be enforced by any magistrate of any place where person against whom it is made, and such magistrate on being satisfied as to identity of the parties and non-payment orders, so and so. So the mode of recovery has not been stated in the section 128. Your lordship may kindly see. There are two parts. 125 said mode of recovery of levy of fine. But insofar as 128 cost provision is concerned, there is no mode of recovery has been laid down. If mode of recovery has not been laid down, then your lordship will have to come to, there is a specific provision under CRPC, my lord. That is 431 of CRPC. (431) says money order to pay recovery of fine. Yes, any money other than fine may be recoverable by virtue of any order made under this code, and method of recovery, which is not otherwise expressly provided for, shall be recovered as if it were a fine. So you provided that section 431 has its application order of so and so, that is different issue. So if it, so your lordship says any money other than fine payable by virtue of an order made under this code and method of recovery of which it is not otherwise expressly provided for shall be recoverable as if it were a fine. So then in case 431, my lord, then your lordship have to recourse to 421, my lord. 421 says, my lord, says, because this question of levy of fine will come. When an offender has been sentenced to pay a fine, court passing the sentence may take action for recovery of fine either in both ways. Issue a warrant to levy of the amount by attachment and sale of movable property belonging to offender. Issue a warrant to the collector of district authorities to realize the amount of area as a land revenue other than the movable, provide a sentence directed as default of payment of fine offenders. That is regarding if there is a default of fine payment, there is a sentence, then he has to undergo. That is a different issue. So when there is a specific provision has been laid down, my lord, the magistrate cannot. We have to recourse to section 431 and 421. But now what has happened in this case, my lord? In pursuance of this order passed by this court, my lord, that is 29/5/2024, I was again taken into custody, my lord. That is the miscase it has come. I was taken into custody, my lord, and I was again sentenced to that your lordship will find in that miscase, my lord. That is
Process will go. You will again custody, then again you will
Yes,
be
my lord.
released. This process will go. It's no. This is the way to you collect the money. You will.
no, the
431 is directly not applicable.
no, but
What is your given? Why you have filed this one?
basically because the court doesn't have the jurisdiction, my
No,
lord.
no. For what? Why you have filed this one? Keep it again.
I'm challenging the order, my lord.
Order.
Order.
Order in which page?
That order passed by the
Implicit order is at page 20.
20, my lord. That order. That order I have challenged, my lord, on the ground, my lord, because 128 doesn't provide so, my lord. Your lordship, that is my function.
There I have at present I but there are provisions.
Because
you have to send him for 1 month in prison.
Because there is a decision of I like to rely on the decision of Allahabad High Court.
Okay, now what is this day you filed it? Now at present, where is he? Is
Now
in custody?
today most probably he is being released because 1 month expired. Like.
1 month expired.
Because there is I like to rely decision of High Court by on Allahabad High Court, relying on the Supreme Court decision, my lord, that a person cannot be sent to jail, my lord.
Hard, Mr. Passport. Hard, Mr. It's an application under constituents. So, it will stop it, but everything has been filed. Challenging the legality and validity of order. It is 29/5/2024 passed by PMFA Nagaon in PB case number 377 of 2007. Submitted by Mr. Kotoki that there is no such provision of taking into custody that provision in the section 120 everything or 128 everything for recovery of money, keeping the person in the jail and the order or recovery of the one has to go for report one has to take the report of section 431 everything where it is provided that the money other than the fine payable by virtue of an order made under court and that the recovery is FCFM. the respondent. Registered it as the also called for the yep. Stop now. Your what for stay of which what thing you want to stay?
Actually, stay of that order, my lord.
Huh?
Stay of the impugn order, my lord. 28.5.
Order.
Yes, my issuing warrant of arrest.
No, order will be. This is not the order. Again, it will be another order will be passed. I mean, this
Yeah, I understand. Right.
Again another. So staying of that order will not serve the purpose because he has already, I mean, released from the, jail after 1 month. So the order is not enforced, I think, at present. Otherwise, you can do one thing. You make a submission on stay on the next day of this thing. Try to take the instructions from the whether he is in custody, he is released.
No, because the order itself says that on 30th he will release, my lord.
On
30th, man. You'll also kindly see the
30.
30, man. Today is 30th, my lord.
That's why I'm saying.
So automatically it will be
instructions.
He will be forthwith will be released, my lord.
He will be released forthwith only.
Yes.
I mean, after 1 month, he will
Yes,
automatically released.
Yes, ma'am.
It is the provision. It will be automatically released. So, staying these things at this stage, you just take instruction and let us know on the next day.
Yes, ma'am.
Whether he is still in custody. It will give you a short date otherwise.
Yes, because your lordship will see Ishan Sangha is sentenced to undergo 1 month 30 days.
Yes.
That is from 1/7/2024 to 37. Today is 37.
Today is 30.
Our payment to Astani whichever earlier. So if he doesn't pay make, so he will automatically today he will be released.
Today he will be released. That's why I'm saying the stay of this particular.
It doesn't make any
doesn't
difference.
make any sense because the question is if such case is there or again he is there.
Yes, ma'am.
On the next day, you just take the instruction and let us know the what
Yes.
about what the present position.
Yes, ma'am.
That only can be. Otherwise, by issuing notice at present.
Yes, ma'am.
And let us see.
But there's a one law point involvement whether recovery can be made by exercise.
There are law. We are also on that.
Because that decision your lordship, I'm sitting by that.
Procedure we are obtaining because 431 is a.
I understand, my lord.
There are some.
Then they must impose to 125 3 years, so my lord, that they must. While levying a fine, you are sending to 1 month custody means you are request to 125 3 weeks. There is a bar, my lord. Power of limitation for 1 year. 1 year has already lapsed, so they cannot exercise that power, my lord.
No, after lapse of 1 year, they have to file a petition that this is and for that reason only what will happen. For 1 year that will be considered. Suppose you file a petition after 3 years or 2 years. Suppose that in last 1 year will be considered. I know that is the procedure. Last one will be considered and then the order will be passed or you may be asked to file the petition.
But court has said that we have exercise power on 128, my lord. But 128 doesn't. That is the difficulty.
That is the 128 is not.
Because
I cannot.
man and miss has come to finding 128, we are exercising the power.
Yeah.
But there's no mode of execution in 128, man. They have go to other provisions here, man.
No provision is there. Okay. So at present we are not dealing with the stay order here.
Yes, ma'am.
Next day we are fixing.
Yes. In a mistake, let us see what orders passed today, my lord. I will.
Yes, obviously. So when do you want? Because you have to issue notice also. That's
Yes.
why I'm asking.
After a week, my lord.
After a week will possible.
Today's order we can get a certified copy and I can enclose that.
No. That is there. That is okay. The service of notice.
A service on yes. Let it after 2
After
weeks.
2 weeks.
2 weeks. Yes.
By that time you take
Yes.
instruction or you can file. What kind of I?
May I please, your lordship?
What is the IA? In fact,
Lordship, initially the case was filed under the provisions of 438 of the CRPC, lordship. That is why IA has been filed.
it ought to be 482.
482, lordship. Now, lordship,
IA
I
is there
would like to take your lordship to
And with regards to
AV.
AP, we have received here. It is the motion stage. It is in motion stage.
Lordship.
Okay. Yes. you can-
Lordship, I would like to take your lordship to the FIR. That is at page 10, lordship. Basically, the case of road traffic accident, lordship, which has been filed in a different way by the father of the LS victim, lordship. Lordship will find the vernacular at page 16, lordship. Here the date has been mentioned as 27/6/2024, although the incident took place on 25/6/2024, Lordship.
Incident took place on
25/6/2024, Lordship.
25.
But in the FIR, it has been mentioned as 27/6/2024.
So as per you, the accident took place on
Accident
25.
took place on 25, Lordship. I will come to that, Lordship. Lordship will find the crux of the allegation is that, Lordship, the father of the victim was informed by the two persons that the victim is lying on the road. Subsequently, the victim was taken to the Tamulpur PHC, and thereafter, for better treatment, he was shifted to GMCH. After a few days, he regained his senses, and he uttered the name of the three persons who allegedly assaulted the victim. That is the story, Lordship. And the name of the petitioner has also been mentioned in the FIR. Now, Lordship, I would like to take your Lordship to page 18, Lordship, Annexure B series. Page 18, Annexure B series. Konkon Rajbangshi, he is the petitioner before your Lordship. And Lordship will find that alleged history of RTA at Tamulpur at 7:30 p.m. examined at 11:40 p.m. This is the prescription of the Swati Hospital, Lordship, on 26/6/2024. Initially, the petitioner was shifted to Tamulpur PHC, and for better treatment, he was thereafter referred to Swati Hospital, and thereafter, Lordship, to the GNRC, because he sustained both head injury and leg injury. In the bottom part, Lordship will find advice CT scan of the brain, X-ray of the right foot, right ankle, shoulder joint, and leg. Now, Lordship will kindly come to page 19. It's a report of the CT scan brain, Lordship. Last part, Lordship, impression. Impression part, linear and branching hyperdensity along with the cortical surfaces of the left high parietal convexity with a few small ill-defined sublet hyperdensity and cortical surfaces suggestive of condition with acute subhemorrhoid hemorrhage, scalp hematoma. And next page, Lordship, page 20, that is the discharge summary, Lordship. It is a discharge summary of the GNRC hospital. He was discharged on 1/7/2024. But he was continuously under treatment, so far the medical report is concerned, till 8/7/2024. Lordship will find at page 24. Statement of account has been prepared, Lordship, and the medicine has been prescribed. Page 24 to page 27, Lordship. Lordship, Annexure D, Lordship, page 30. That is the complaint lodged by the wife of the petitioner, Lordship, before the Court of Learned Chief Judicial Magistrate Baksa, narrating the entire actual story, actual fact of the case, Lordship. That has been registered as a CR case number 99 of 2024, filed under section 281 and 125 of the BNS. Page 33, Lordship, will find a copy, and page 31 is the translated copy, Lordship.
This complaint was filed by?
This was filed by the wife of the petitioner, Lordship. Because the petitioner was undergoing treatment, he was not in a position to file the complaint. So his wife filed this complaint on 12/7/2024, Lordship, after discharge of the petitioner from the hospital. Now, my only concern, Lordship,
Against whom allegation is?
against the alleged victim, the son of the informant, Lordship, that he was coming by riding a motorcycle, Lordship, and the petitioner was walking in the road. He hit the petitioner from behind, and subsequently petitioner sustained injury. He became senseless, and the petitioner was taken to the Tamulpur PHC initially, thereafter to the Swati Hospital, and thereafter he was referred to GNRC. In the GNRC, he was discharged from GNRC hospital on 1/7/2024, and he was under treatment till 8/7/2024. Now the allegation against the petitioner is that he have assaulted, Lordship, a injured person who was undergoing treatment since 25/6/2024. Can he be in a position to beat that person, Lordship, the victim? In fact, what happened after hitting the petitioner from behind, he failed to control himself and he fell down from the bike. He also sustained injury. And both of them were taken to the hospital by the villagers also. He was also treated at hospital, the victim. And the petitioner was also treated at GNRC. That is the actual fact, Lordship. Now, initially the case was registered under section Lordship 325, 341, 506, 379, and subsequently section 307 has been added. And petitioner before your Lordship is a teacher, assistant teacher of Devojani Lahiri Vidyapith MES, ME High School, Lordship. Lordship will find paste at page 37 Annexure F. That is the identity card. I am yet to be cured from my illness, Lordship. And this FIR has been lost narrating my name. And I was at the hospital at that relevant point of time.
Yes, Lord.
While he narrated the actual fact, he also admitted that initially the victimized person was admitted in Tamulpur PSC. Thereafter, shifted to Ghobrapar Medical College, and thereafter, shifted to GMCH. So, victim person was injured, and thereafter admitted in hospital. So, because his injury was may not be grievous, but he was injured and thereafter admitted into various thereafter shifted to and finally to GMCS.
Obviously, that part is admitted that he also sustained injury. But the
Yes.
question is, he alleged that these 3-4 persons assaulted him.
Assaulted.
That is the question. Otherwise, injury sustained by him or by the victim is
Yes.
not disputed, I think. He
Whether-
sustained injury, that is
Yes.
admitted. But the question is that whether it is out of an accident or whether someone assaulted or including the present
Yes.
petitioner.
Whether he is directly involved in hitting the
Yes.
petitioner in fact. Let him
Just
appear,
keep
record
looking.
his statement, and CD may be called.
We are not What about this group or it will think or close it or data people. That not part the what then then submitted by that the present equipment both of petition are being brought against the petition. If further submitted beyond the incident happened accident on 25.
On 25, Lordship. 25/6/2024.
There was an accident 2024 when the informant the victim hit him by familiarity of the type and for which he sustained previous person and he was taken to first you have taken to
Lordship,
first you have taken to which hospital?
I was taken to Tamulpur PHC, then to Swati Hospital, Rangia, then to GNRC, Lordship. Not Guwahati.
He was referred where from he was featured on one supported some medical including the CT scan where from he said it sustained fracture on leg and hand apart from that was sustained head injury. That effort submitted that a person was dead in an accident and was admitted to hospital cannot assault a person with him and it is and with all presented by however it admitted that victim also sustained some injury as it does not constitute second present. However, the education willing for I it begins run contact Mr. What that that as per the present petitioner of Naman has contact it for it sustain it with that is also it and sustain and the injury sustained by the however it submitted as one okay, will be under interim protection.
Lordship.
Yes.
On my lord, 6-9, my lord.
6-9 appear before the IO within 7 days.
7 days.
From the date of order. Now, this I is for correction.
Correction. For wrong quoting of the section, Lordship. Quoted as 438.
Next, I at the next one. Then application for prayer for correction of the cost letter of the collected cost letter of the AB bill AB application AB number 190/2024, wherein inadvertently section 438 has been quoted instead of the proper section of 480 ENSS what present I is enough and the application file in AB 190/2020 will be read as application 480.
Lordship. Oblige, Lord. Brief, Lord.
I at the I at the yes, কৰিব লাগে এইটো হ'ব জানো এটা ফোন
My lord, in this case, I am being led by Mr. A.M. Bora. Due to some personal reason, he had to leave. I humbly pray, can it be taken up some other day?
I saw him at that time. He was
Yes, he was here, but he had to leave.
And my lord, here your lordship in the record also some of the my lord 164 statement and 161 statement are not at all legible, my lord. Your lordship may kindly and some of the your lordship may kindly. Yeah, otherwise, because matter is serious, my lord. So,
these are 164.
yes, 164, 160. And in this case, my lord, initially one accident occurred, and thereafter, my lord, the person who caused the my lord, who is also my lord, caused the accident. My lord, thereafter, a gang of people also, my lord, brutally assaulted and killed him. That is the case, my lord.
And killed him.
Yes.
But we have come up against the framing of charge under 302.
So without those legible copies, my lord, it would be difficult to.
You know, the LCR is here. LCR is here. As per the cause list, the LCR has come. Scan
So,
copy.
my lord, legible copy will be required.
Then
my lord.
And
here,
in our
no. He
my
is
lord,
saying that
a
the
legible copy
is not visible.
In like 164, 167.
Immediately.
But
But for your lordship's ready assistance, my lord, we had annexed all the copies that we had got in our petition 161 and 164. However, as my learned friend has pointed out, then LCR may be called for if it is not legible.
Legible copies, man.
Otherwise, he will not be able to argue.
LCR case is most probably pending. There's no stay.
Stay is there.
Stay is there.
Stay is there.
Stay is there. That original copy can be called for. Or I don't know if stays there or
May,
not.
yes, my lord, stays there, stays there.
Then original maybe confirm each stay is already there or not.
Each stay.
Because if other accused person is also there, that will
Oh, that I
only regarding other accused
stay
person.
is for you.
Stays for me, my lord, stays for me.
Only for you.
Only.
Then to LCR has to be called. Scan copy.
Legible copy. ma'am.
On 27 9.
You are appearing for the informant side?
Yes, ma'am.
No, no. I just submitted by Mr. Bott that they do the scan copy of the LCR. But the 164 and 161 statements of the witness as well as victim are not properly are not legible, and hence the break would call for a legible scan copy. Scan copy. In case this the exam of the break by that of the person the case Mr. Dean to the court. Registry they were direct call for a legible scan copy of the LCR along with this guide. But case is pending since 21, so
Yes,
that is
madam.
why I mean already the
Mm.
criminal
It is not
petition
there,
case is pending. Huh?
Yes.
Kindly sort them. Kindly sort that maybe.
It has to come from which place?
Amingaon.
Amingaon.
Mm.
Then we can give a short date.
Yes. ma'am.
12:30 can be given.
From 28 month.
2-8.
Oh, not no
20.
20
20.
20.
20. Yes.
My lord, the interim may continue, my lord.
Interim was there. Interim we can do next.
Obliged.
It was.
I am for respondent here, Lordship.
19. You are for the respondent.
Respondent, Lordship. Lordship, they have also filed this case without Lordship annexing all documents, Lordship. Only the judgment is there, Lordship. Other, whether the evidence claim they are, this is not there, Lordship. Even the case also, Lordship, only 1 lakh is given as permanent element, Lordship. That much is challenged, Lordship. Only one.
There is no stay, I think.
No stay there. So, Lordship, maybe directing them to annex all these documents. Otherwise, we also cannot, Lordship, no longer able to argue this on the matter, Lordship.
You are saying that documents are not annexed. One judgment is annexed here.
Yes, only that. Other Lordship, what is my plaint, their statement, their what is the evidence is crossed, these are required, Lordship. It is a revision show, Lordship, what the other documents that is also required, Lordship. Also, he also has not interest, Lordship, he is absent today. And sometimes, Lordship, what I know, Lordship, they are also misguiding this trial court, Lordship. Even there is no Lordship, but they are saying that sometimes they say that court has given stay, so you cannot ask me to pay. Again, on the last day, he said that the court already accepted my pleading, so I need not to pay. So this way, Lordship, they are misleading this trial court, Lordship. Otherwise, we are also claiming there is a 4-month time was given to make the payment. And now,
Why don't you file a petition before the London
yes,
trial
file,
court?
file, Lordship, that
File
now,
and say that if there is suppose any stay or any order is there, they can be asked to file all this
yes,
before the
yes,
court.
last time,
Otherwise,
Lordship,
how can
last time even
clear
Lordship, they from the court, Lordship, they also called me, Lordship, to take the clearance, Lordship. I told them no, there is no any stay. But they even told that the already court has accepted our pleading, so we need to pay again.
that should not
This
be?
is they made. So Lordship may only on clearance may be given, Lordship, till that there is no any stay, so they may proceed as per law. Here also, he's also not interested to play the case.
The non-appears on call for the petition side, part F of the London Council and submitted by Mr. Hawk that the petition is supported with only the judgment passed by the court and other relevant documents are not annexed along with the petition. And accordingly, he submitted that the petitioner may be directed to furnish all the relevant documents, including the WS. Further, it is submitted by Mr. Hawk that that though there is a There is no stay order by this court.
The directory is page 23.
But the respondent is respondent is saying the respondent is sorry, the petitioner is
page 26 में काम लो.
petitioner is submitted for the London Trial Court with the there is a stay order and stay order passed by this court, and accordingly they are not entitled to pay any alimony as per order of the court. Full stop. But on the case record, since there is no stay order passed with date dated and according, and hence the London Trial Court, London principal just is at liberty to proceed with the case. This is the matter after.
Hello, hello, sir.
Met Your
Yes.
Here also the one interlocutory application is pending for suspension of sentence and releasing him on bail. Okay. Here he was convicted under section 304B for 10 years.
Yes. State, whether the state has filed any
Yes, they have
objection?
filed their objection and informant also appeared. Here from the record, what you will find from the record, you will also find that after 1 year of marriage, that wife of the present appellant committed suicide. That is suicide that is admitted by the trial court also, and that is found in the post-mortem report also, that suicide. And now the question is that whether there are ingredients of section 304B or not. Because to prove a case under section 304B, there has to be 4 ingredients. First, lordship, that there has to be death within 7 years of marriage. Then lordship, that she was tortured in connection with dowry demand. That has to be there. But what I find in the record, subject to what my learned friend says, lordship, I find that there is no material to show that there was demand of dowry. And in that demand, she was tortured. That torture has to be in connection with demand of dowry. That part is not there. Here, lordship, one suicide note is there. That is exhibit 1. That is exhibited. Your lordship may kindly see that exhibit. Material exhibit 1 in the record.
The record.
Yes. That will clarify the entire aspect, because after her death, relatives of the girl has raised some issues in their evidence, but those were not in the FIR, not there in the FIR. Material object 1. Lordship, go.
The entire book is material.
No, 1 page is there, lordship.
What kind of documents they took?
No.
This is the suicide note.
Suicide note. And it is nowhere it is alleged that there was demand of dowry, and in connection with that she was tortured. That part is not there.
We will see to it after what it says then, yes.
Here, Lordship, some other facts are discussed that there was some marital discord, and marital discord will not automatically lead to that 304. But that there allegation some marital discord is there. But apart from that, there is no allegation that demand was there, demand for dowry was there, and in connection with that, she was tortured. That is not there.
Yes.
So your Lordship has seen that the demand of dowry that is not there, and just I am reading the FIR, Lordship. FIR in the FIR also your Lordship will not find that aspect. আবেদনকাৰীৰ বিনীত নিবেদন এই জানিব যে মোৰ ছোৱালী মৃত জ্যোতিক ৰায়ক দক্ষিণ বুঢ়াগাঁও গাঁও নিবাসী মৃত ৰায়মানী ৰায়ৰ পুত্ৰ শ্ৰী যতীন ৰায়ৰ লগত আজিৰ পৰা প্ৰায় 18 মাহ পূৰ্বে বিয়া দিছিলোঁ। সিহঁত স্বামীৰ মাজত কিবা মতৰ অমিল হোৱাত, so Lordship kindly see that কিবা মতৰ অমিল হোৱাত, কিবা মতানৈক্য বাবে আজি হঠাৎ মৃত্যু মুখত পৰে। পাছত আমি অনুসন্ধান কৰি জানিব পাৰো যে মৃতকৰ ডিঙিত কলা দাগ দেখা পাওঁ। আমাৰ সন্দেহ হয় যে জোৱাই যতীন ৰায়ে ডিঙিত ৰছীৰে চেপি মৃত্যু ঘটাইছে, নাইবা ছোৱালীজনীয়ে নিজ আত্মহত্যা কৰিছে। So at that point of time also there was no allegation of demand of dowry. And just I'm taking your Lordship to section 304. Those 4 ingredients are mentioned in the section itself. 304B. Where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death. So torture in connection with that demand has to be there to attract section 304. Just I am relying on a judgment of our High Court Lordship. Para 25, Lordship may kindly see here one Honorable Apex Court judgment is quoted. In order to convict an accused for the offense punishable under section 304B IPC, the following essentials must be satisfied. Number 1, the death of a woman must have been caused or by burns or bodily injury or otherwise than under normal circumstances. Number 2, such death must have occurred within 7 years of her marriage. Number 3, soon before her death, the woman must have been subjected to cruelty or harassment by her husband, or any relatives of her husband. 4. Such cruelty or harassment must be for or in connection with demand for dowry. When the above ingredients are established by reliable and acceptable evidence, such death shall be called dowry death, and such husband or his relative shall be deemed to have caused her death. If the above mentioned ingredients are attracted in view of the special provision, the court shall presume it shall record such facts as proof unless and until it is disproved by the accused. However, it is open to the accused to edit, so this part I am skipping, Lordship. Then Lordship may kindly turn to paragraph 30, Lordship.
Yes.
Even if it assume for a moment that there was at one point of time the accused wanted money from the mother of the deceased, then the relevant issue required to be considered is whether such demand on part of the accused fulfills the test of proximity so as to come within the expression soon before her death. It is apt to refer the above observations made in this regard by the Supreme Court in so-and-so with regard as under, which reads as under. To attract provision of section 304B, one of the main ingredients of the offense which is required to be established is that soon before her death, she was subjected to cruelty or harassment for or in connection with the demand for dowry. The expression soon before her death used in section 304B IPC and section 113B of the Evidence Act is present with the idea of proximity test. In fact, the learned counsel appearing for the appellant submitted that there is no proximity for the alleged demand of dowry and harassment with regard to the said claim. We shall advert to the same while considering the evidence laid in the prosecution. Though the language used in soon before her death, no definite period has been enacted, and the expression soon before her death has not been defined in both the enactments. Accordingly, the determination of the period which can come within the term soon before her death is to be determined by courts depending upon the facts and circumstances of each case. However, the said expression would normally imply that the interval should not be much between the cruelty or harassment concerned and the death in question. In other words, there must be existence of a proximate and live link between the effects of cruelty based on the dowry demand and the death concerned. If the alleged incident of cruelty is remote in time and has become stalled enough not to disturb the mental equilibrium of the woman concerned, it would be of no consequences. So in paragraph 31, what you will find, even if the event where the accused wanted some money from the mother of the deceased at one point of time, which albeit is without any specific details of the same, is taken into consideration, the same cannot be considered to have fulfilled the test of proximity. Here, why I am referring to this paragraph, Lordship, that during evidence, the relatives have said that at one point of time he demanded dowry, but when demanded, how demanded, that clearly nowhere it is found. And from the suicide note also, there is no allegation of demand of dowry, that that she was tortured in connection with demand of dowry. And paragraph 32 also relates to that soon. Soon word is and soon, those were defined, Lordship, that how it has to be dealt with. So my humble submission before Lordship is that from the present case, the basic ingredients to convict him under section 304B is not there, Lordship. And therefore, considering the same, Lordship, at this stage, he may be granted bail, Lordship. And during trial also, he was on bail, Lordship. That part your Lordship will find in the appeal memo, page 15, in the judgment itself. that he was arrested on 10/1/2014. Then he was released on 2 February 2014 after 1 month 10 days. So he was in custody 41 days. And presently he is in custody from the date of judgment, that is 21/8/2023. He is in custody.
May I plead your lordship? I am appearing for the informant, the respondent number 2, your lordship. My humble submission before your lordship is that the learned trial court below is fully justified in sentencing the accused under section 304B for 10 years rigorous imprisonment, your lordship. Your lordship, in this case, all the ingredients of section 304B are fulfilled, your lordship. The deceased has died within 18 months of her marriage, and she has been subjected to mental and physical cruelty by her husband and the relatives of her husband in connection to dowry demand, your lordship. Your lordship will kindly see the evidences of PW 1, 2, and 3. They have fully corroborated the dowry demand of 50,000 rupees and a gold chain. And for that, she was harassed, and which led to her suicide, your lordship. In her suicide note also, she has clearly stated that due to mental and physical cruelty, she has been compelled to take her own life, your lordship. Your lordship knows section 304B clearly says that, may I read 304B, your lordship? Where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Your lordship, in this case, all the ingredients of these sections are fulfilled. So there is an irrefutable presumption under section 113B of the Evidence Act that dowry death has been committed, your lordship. Your lordship, moreover, the suicide note is contemporary in nature as it has been corroborated by PW 1, 2, and 3, your lordship. And lordship will kindly see the inquest report, your lordship. In the inquest report, the time of death is shown as 11 a.m. But during evidence, it is found that the relatives of the deceased has been informed at 12:30 to 1, in a lapse of 1.5 hours to 2 hours. This shows that they want to suppress the matter. Even when the relatives of the deceased went to the matrimonial home, your lordship, they have been misled. They were told that she fell in the bathroom and she died. So due to this misleading, they could not clearly state in the FIR what has happened to their daughter, your lordship. Moreover, your lordship knows that FIR is not the encyclopedia, your lordship. It just sets the investigation into process, your lordship. This suppression is also relevant under section 8 of the Evidence Act, your lordship. And so the subsequent suppression of the matter, the fulfilling of all the ingredients of section 304B, which leads to irrefutable presumption under 113B of the Evidence Act, your lordship, all this leads to the conclusion that she was harassed mentally and physically in relation to dowry demand of a gold chain and 50,000 rupees, your lordship, which compelled her to take her own life. A girl of 20 years of age, your lordship, who used to write her diary, a very sensitive girl, she has been compelled to take her own life due to the cruelty of the family members of the husband and the husband himself, your lordship. This is my humble submission before your lordship, that he should not be set at free at this stage, your lordship. In this connection, I am submitting some judgments of the Honorable Apex Court, your lordship, regarding the term soon before in connection with dowry demand, your lordship. I am placing the judgment of Sadbir Singh, your lordship, and Gurmeet Singh, your lordship. May I read the paragraph, relevant paragraph?
just want to supply.
Yes, sir.
These are the paras you are relying.
Yes, Your Lordship. In Satbir Singh and another versus State of Haryana, I am relying on para 19 and 25, Your Lordship. In para 19, this court in Bansilal versus State of Haryana emphasized the mandatory application of the presumption under Section 113B of the Evidence Act once the ingredients of Section 304B IPC stood proved. It may be mentioned herein that the legislature in its wisdom has used the word shall, thus making a mandatory application on the part of the court to presume that death has been committed by the person who has subjected her to cruelty or harassment in connection with any demand of dowry. Therefore, in view of the above, the onus lies on the accused to rebut the presumption, and in the case of Section 113B relatable to Section 304B IPC, the onus proved shifts exclusively and heavily to the accused. Therefore, in case the essential ingredients of such death has been established by the prosecution, it is the duty of the court to raise a presumption that the accused has caused the dowry death. Para 25, Your Lordship. Therefore, if all other ingredients of Section 304B are fulfilled, any death, whether caused by burns or by bodily injury or occurring otherwise, then under normal circumstances, shall, as per the legislative mandate, be called a dowry death, and the woman's husband or his relative shall be deemed to have caused her death, unless proved otherwise. The section clearly specifies what constitutes the offense of dowry death and also identifies the single offender or multiple offenders who have caused the dowry death. Your Lordship. I am placing another judgment, Your Lordship. In Ahola Devi and another versus State of Jharkhand, Your Lordship. I am relying on para 2, Your Lordship. Second paragraph, fourth line, Your Lordship. The legislative intent of incorporating Section 304B was to curb the menace of dowry death with a firm hand. In dealing with cases under Section 304B, such legislative intent has to be kept in mind. The offense under Section 304B, offense of dowry death, is the offense against society. Such offenses have serious impact upon society. Keeping in mind the aforesaid aspect, imposition of sentence for the offense of dowry death is required to be considered. A strong message must go in the society that the person who commits such an offense of dowry death and or the offenses under Dowry Prohibition Act shall be dealt with an iron hand. So my humble submission before your Lordship is that in view of the suicide note and the evidences of PW 1, 2, and 3, which corroborates the suicide note, Your Lordship, and the demand of dowry of a gold chain and 50,000 rupees, and in the it fulfills all the ingredients of Section 304B, so the accused should not be let free, Your Lordship.
Already, he has already pointed out the relevant facts, Lordship. I will just point out, Lordship, one paragraph 27 of the judgment, Lordship. Just the observation of the trial court, Lordship. Finding paragraph 27. Yes, Lordship. Paragraph 27, Lordship. A visual examination by the court of the suicide note and the notebook also shows that the handwriting are of the same person, the deceased. The suicide note, amongst others, reveals that the deceased did not get any peace even after 1 year of marriage, and that she suffered verbal abuse, physical assault, but went on tolerating the same, and that she no longer can tolerate the same.
The suicide note therefore further confirms the testimonies of 1, 2, and 3, as he has already pointed out, Lordship, and is admissible under section 32(1) of the Evidence Act. I will just leave out this portion, Lordship. Paragraph 28, Lordship, just a few lines. The combined effect of the evidence of these three PWs as well as the suicide note of the deceased overwhelmingly proved that the deceased was subject to cruelty, physical and mental, at the matrimonial house in connection with demand of dowry by the accused. And Lordship, failure of the informant to narrate about the demand of dowry in the Ezahar pales into insignificance in the light of the corroborative testimonies of PW 1, 2, and 3, coupled with the suicide note. So that argument which was made by the petitioner, Lordship, that there was no indication of demand of dowry in the Ezahar, Lordship, that has been taken care of by the trial court, Lordship. Now, Lordship, will kindly come to one more paragraph. I will just point out, Lordship. Paragraph 44, Lordship. Only this paragraph, Lordship. Repeated revelation by the witnesses about the nature and manner of cruelty meted out by him to his wife therefore confirms that it was he who subjected her to such cruelty which forced her to take her own life. This revelation of subjecting the deceased to cruelty by physical and mental harassment in connection with demand of dowry could not be disclosed by the accused while under examination under 313 or by adducing any defense witness. Therefore, the presumption envisaged under 113B of the Evidence Act squarely covers the case of the accused that it was him who caused dowry death of the deceased by subjecting her to cruelty as required to be proved under 304B of the IP. But all the materials are there, it has been taken care of by the trial court.
Here in this case, Lordship, that 113B of Indian Evidence Act, that will come into play only when they prove the ingredients of section 304B. That 113 will be to that a husband or relative has committed the offense, not to the to prove the offense, Lord. It is related to they have committed the offense. To prove the offense, they have to prove it by their own evidence. They cannot take help of
As per the prosecution or as per the submission made by the counsel for the informant,
Okay.
PW 1, 2, and 3 all are corroborating that he demanded.
No, that therefore, Lordship, I have referred to paragraph 31 of the judgment which I have relied on. There has to be specific time when it was demanded, because it cannot be in the when marriage was solemnized, then they demanded, and subsequently after 18 months she died, and therefore you can connect with that. That cannot be. They have to state the specific day, specific time. That they may show, Lordship.
In the evidence of PW 1, 2, and 3, it has been stated how she used to come to her house and narrate how she was tortured in her matrimonial home to her father and her sister. But as they were poor people, she was asked to go to her matrimonial house, as the society will say bad things if she stays in her parents' home. These are things stated by in evidence by PW 1, 2, and 3, Your Lordship.
Specific allegation has to be there that before 1 month, before 2 months, he demanded dowry, and therefore she was subjected to torture. When demand of not fulfillment of that demanded money. That has to be there. Therefore, Lordship, I have stressed on that section also. Section also says that torture in connection with demand of dowry. Merely demand was there, torture was there, but those are not interconnected, then that cannot be said that ingredients of section 304B is fulfilled. First, if they say that section 304B is fulfilled, then court will presume under section 113B that husband failed to discharge his burden, so he is the guilty. First, they have to show the ingredients. They cannot take the help of 113B to substitute the ingredients, Lord.
Lordship, in the judgment of Sadbir Singh versus State of Haryana, it has been explained elaborately, Your Lordship, how soon after should be explained as a proximity and live link. There should be a proximity and live link between the demand of dowry and the death of the person, Your Lordship.
Yes, that is what my
Soon
submission
after,
is.
there
If they can show any evidence that they have said that they are soon before her death, soon before
soon
her
before
death,
does
even
not mean that there should be specific time. Soon before is a relative
even
term.
Lord,
It should
there
be-
has to be something for the court that this torture, this demand was within this period, and for that she was tortured, and subsequently she
18
committed
months.
suicide. That is what I am submitting. That in the when marriage was solemnized, for assuming that that accused had demanded money of 50,000 at the time of marriage. Subsequently, there was nothing. They led their conjugal life for 18 months. Subsequently, she committed suicide. How that can be connected, Lordship? That is my whole submission to your Lordship.
Your Lordship, the suicide has been committed within 18 months of her marriage, Your Lordship, in unnatural circumstances, Your Lordship.
No, Supreme Court in thousands of judgments
Your
said
Lordship
that
will
4
kindly see
ingredients has to be
the
there. All
para,
the 4 ingredients.
para
Lordship.
27 of the judgment, Your Lordship. Just in the suicide note, it has been stated how she was subjected to mental and physical torture, which led her to take her own life. A girl of 20 years of age is compelled to take her own life, Your Lordship.
Is
If
there
that's
anything in this suicide note regarding the dowry?
Mental harassment, Your Lordship. She has stated.
Regarding demand of dowry, is there any?
Regarding demand of dowry, it is not stated, but she has stated before her family members, Your Lordship. PW 1, 2, and 3.
She stated she has written a long suicide note, but there is not a single whisper about demand of dowry. She has said about not getting child, no, those other mental cruelties, or everything she has stated.
But in
And
3G,
even if we admit that that those things are there, then also there at best it will be under section 498A. That say provision is also there. That if she commits suicide, then 498A will be there. That in connection, just I am reading that 498A, Lordship, placing that. And then maximum punishment is 3 years. Then if he is pending appeal, he would have been out.
physical and mental harassment is also
Just
one of
your-
the ingredients of section 304B, Your Lordship.
Your MA?
F. Hussein.
And the next, what's the definition of set? That is the it. For the past 5 years, 21 by that I think that what I want to find it for at that point. Also pay for release of pay staff not that that gets evidence it be I think to take presumption one if before the sub in the FI in the FI of there's no statement of that on the by of the acceptable of that epic epic would be that what has been but to compete if compete as required it also the independently quantity to technography on doesn't take any but demand of demand of demand of deputy for uh, culture on part of demand independent. In context, Mr. Ahmed Badr died of export and based on data that it just that put that died on the question of the export. The export. In case of Mustafa Sahabat and Shahadai Sheikh Supra were only discussing about the export fee. It has been intended when it by that acceptable evidence. Such case can fall with the doubt without and the court shall be that but the but it so but one by and whether that not of the court that it is not for uh, but at the rate of trial pay it for enough for action pay it could as recording that was on then one report pay on other report and thereafter the entire period of time it was not paid. It was not paid. So that was the standard pay and with and and the get duty and duty but uh but that that aspect and but but it that means case of and it will be case of case of 493. But there cannot be happy what it did for the system of that faith with it and not its evidence against the subject one detected that accused evidence should not be put the not put the detective subject if victim was subjected and but subjected the death it was but the act 11 but captain first of the it was about the death only but one that more than one half about it it was does it was subject it may be one of it or subjective metric and it may no subjective it MS Hussain further submitted that the done it that just it past the order of consent and in a parametric when of the consent it is well discussed by the would be of there was one the and also discussed about that to confirm the testimony of the one. It's safe for us relying on of certificate and the case of certificate of effect code. The of the effect code was in case of certificate reported that reported that 2021 but it was that good before cannot constitute by means immediately before and the existence of proximate and type link between the dowdy debt or harassment for the month of she also relied another of the effect code of Ajkola Dev and another for the state of Jharkhand and it relied on para 2 of the state judgment. So, according to the base of subjected not all of the case it can then before the term that that would be and thus it of when when it is edited to evidence of the and again did not parameter judgment but Defend confirm the group 130 and not according to the authority then repeat as submitted for one to cycle of however that video one from the so demand of the present but on it one it denote that the because the method on her by of the third of the going the detail of the it or the quarter the part of video that but it of it why the brand with what to take on aspect of what the where it is when it is for
It is additional session judge number 2, Nagaon.
your petition is allowed.
Obliged. That sessions case number will be mentioned. Also. That sessions within
Mention
bracket
it.
P1.
We'll mention. I'm just started. We'll mention.
Obliged. Just I have one prayer, Lordship, that item number 42, Lordship. This is regarding maintenance. And only one issue is I have, Lordship, that there is no disclosure affidavit is filed. No
Yes, what you say?
in item number 42, this is regarding maintenance, Lordship. My only issue is that there is no disclosure affidavit in terms of Neha and Rajnesh. That is not there. So small issue that
I'm
may,
not supposed to hear.
no, Lordship may fix it any short date, Lordship. Only that because otherwise, if your Lordship,
You will fix.
Lordship, obliged.
Lordship, regarding item 32, Lordship, this juvenile case, Lordship, Lordship may remember, Lordship, juvenile was convicted. That order was upheld, Lordship. Only, Lordship, 3 years imprisonment is there, Lordship. And now, Lordship, this pending 389 petition is pending for only the suspension of the sentence. That can be considered, Lordship.
No, I'm not going.
Lordship, last day, Lordship, I placed that all the judgment, Lordship, regarding.
Be listed another date. Right?
Your
Not
Lordship,
today.
regarding item number 30.
Yes, Bort Thakur, but can be listed this next week. It can be can it be listed on next week? This case because he is a juvenile, he is under suspension. Item
That
number
was 32. Juvenile, Lordship, that
No,
juvenile.
I'm not in a position to hear. Next week can be. Next week could be 7th of August.
My lord, regarding item number 33, Your Lordship, the person, Your Lordship, it is IA fixed for the suspension of sentence, Your Lordship. It was the accused is lingering in jail 19 January 2024. Okay, already 7 months.
Can
done
be
in-
listed on yes.
on
Can.
2nd of August, can it be possible?
Not at all possible.
My
2nd
lord,
of
in-
August, will not be here. We are a meeting actually. 2nd of August, not at all possible. Next week, any day. Okay. Not even exactly next week. Next week, lots of matters have been fixed. I think it will be a difficult position.
22nd, my lord. 22nd.
22nd will be because your lordship, some medical reasons are also.
You are also in that.
Yes, I am
The
for the private respondent.
Oh.
My lord, in
Can-
this case, my lord, already one of the accused, my lord, he already escaped, my lord. Trial could not be
That is not the
conducted for him, my lord. And my lord, his conduct is also not good, my lord. So I will pray, my lord, let the case come up for final hearing only, my lord.
It is for IA, your lordship.
Otherwise, it is ready for hearing.
I reading.
Ready, my
your
lord, let it be heard finally and decided, my lord. 10 years given, my lord.
Then 9, your lordship. Can it be 9?
Final for final disposal, my lord. On 22nd of August, my lord.
Final disposal, please. I'll fix for IA, your lordship.
No, IA, my lord, all together, my lord. No, not
Can be
required for
heard, no
piecemeal,
issue.
my lord. Yes, my lord. Piecemeal manner, my lord, again.
22nd August will be
Too late.
Your lordship. So my
15,
humble prayer,
14
lordship.
months.
Can it be
16th August, my
8
lord.
or 8 or 9, your lordship.
30th of August, entire matter will be heard. Okay.
Yes, my lord.
Lordship.
30th of August for the final hearing. List the matter on final hearing along with the I on aggregate.
30th.
Grateful, my lord.